Good morning. Good morning, everyone. Good morning. Good morning. Um, Summer, I just saw that he had a hearing, so I'm gonna have to tap into that too. Good morning. Good morning, y'all. Sorry, I'm behind. Oh shoot, hold on. I really wasn't supposed to be behind because I've been up in enough time, but y'all know my ADHD brain. Anyway, good morning, y'all. Y'all know we're doing Melly's hearing today. Kat is streaming Stefan's hearing because when I got on, I saw that she was live streaming Stefan's hearing today. So I'm going to watch it. I don't even know what this case is about, so I need to see what it's about first to see if I want to watch it. But yes. Yes, that's what I saw, Summer. Hey, Summer. Hey, Crystal. Good morning, Paris. Good morning, Gariel. Hey, Alice. Good morning. Good morning. I'm going to say, hey, Ebony. Hey, Laura. So I'm going to go ahead and start sharing my screen because I think it's exactly 3 hours long and that's how much time I have. So let me share the screen and we can get started. Now, I don't know if you all have seen this before. I haven't seen any of it at all. Hey, La Paris. I mean, La Panda. I said La Paris. Good morning, Sonia. How are you? Hey, Ashley. Good morning, Brianna. So I haven't seen any of it. I am excited to see Drew because I hear a lot of great things about him. So I'm happy to see him. Hey, Mama Jenkins. How are you? Hey, Cece. Well, Cece, I'm going to be live from 9. Well, no. When court is on, it should be 9 until 12 when court goes off. And then I'm going to do some recaps on David and stuff like that. So I'm trying to do it before I go to work, girl. So we're going to see how that works. So we're going to go ahead and start.
We have rebuttal witnesses. Yes, it depends on what they say if we call witnesses. And as to prong one, we would just simply be relying on the court's previous
Good morning, Tracy. Good morning, Gina.
order, the transcript Your Honor has read, and the prior submissions for.
Yeah, listen, I'm going to rely on what I did previously, but I'm not prejudging anything. I'm going to.
Hey, Miss Sims.
I'm happy to hear everything that both sides of my position. I'll make a decision and maybe the right deal with this case than I did the last time. I remember in the last review motion, there was no witness. There was no evidence. Arguing what they want me to do. So that's what was in front of me. So that being the case, in defense, I'll let you present whatever evidence, witnesses, or testimony you'd like in support of your motion. If there's anything that you would like to do, when you're ready, you may proceed.
Thank you, Your Honor. So, yeah, here's the part you want. Thank you, Your Honor. Your Honor, I can just let you know that defense's plan for how to proceed with the court's permission. And that is, yes, on prong one, we're prepared to argue prong one. Regarding prong two, we do have 5 witnesses, and we did notify the state via email on April 20th. We gave them the names, addresses, contact information.
So if it's just a legal argument relying on previous evidence, witnesses, testimony, trial transcripts, everything that's in there as to proof evidence, presumption, rate, just your argument, pause on that. And if you want to just call your witnesses as to the second part, which is even if I was to continue to find that, you want me to exercise my discretion in order to inform the trial case. So I'm happy to listen to this.
Sure. So you want us to do all the argument at the end? Sounds good. Thank you very much. And Your Honor, so we don't forget, Ms. Howitt and I, at the end of the hearing today, we're just going to go over some procedural requests of the court and the state. I think everybody will agree to, respectfully to the other lawyers from the last time. We just kind of studied some things that we'd want to avoid for kind of a trial that doesn't have 3-hour pauses and things like that. And so I don't want to forget to do that. We think, we know you did a replete trial order last time, and we just want to visit that and reaffirm the importance of that. And perhaps a set motion calendar, so there isn't any delays when we try the case in January.
Sounds good.
Okay, thank you very much.
Whenever you're ready, you can call your first.
Thank you. Your Honor, at this time, we'll call Audrey Gross.
She outside.
She's here.
I still have court deputy. So, ma'am, come on up, and you leave your purse there, and I'm gonna have you step right up here to the witness stand. And if I gotta come all the way up here to the witness stand. Once you reach it, but before you have a seat, you can just stop and look at me. Raise your hand. Swear to tell the truth, whole truth, nothing but the truth.
Yes.
Okay, watch your step up. And then once you are seated, I can get you to scoot that chair forward. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
My name is Audrey Gross.
Yeah, you talk normal, you talk in the microphone.
My name is Audrey Gross, Audrey, Gross, Gross.
Thank you. Ms. Gross, if you would, can you tell us where you reside? You don't have to give us the address, but where part of Florida you reside?
I reside in Jacksonville, Florida.
And ma'am, are you related to Mr. Jamell Demons?
Yes, I am. I'm his grandmother.
Okay, and can you tell His Honor what your familial connection is to him? How is it that you're his grandmother? Whose parent are you, etc.?
His mother is Jamie King, which is my daughter.
And ma'am,
Why is she talking
do you remember, can you tell us when Mr. Demons was born, where did you all live?
We lived in Vero Beach, Florida.
And up until shortly before your grandson's arrest, where did you live at that time?
Vero Beach, Florida.
And did Mr. Demons live in that location?
Yes,
And now, shortly before being arrested in the case that brings you here today, did he move to a different part of Florida?
yes,
Okay, and what part of Florida was that?
Miami.
Now, what were you active in raising Mr. Demons?
Yes,
Okay, and there were some unique circumstances. His mom, I believe, was young.
yes.
Okay, and how old was his mom when Mr. Demons was born?
14 and a half.
And what role did you play in raising Mr. Demons?
I acted as if I was the mother as well, and when his mother came home, I gave her that responsibility because I didn't want her to make that mistake again.
And when you say came home, what do you mean?
When she came home from school, or if she had her part-time job, she made sure her baby was taken care of, and she did an excellent job.
And did she go back to school and continue her schooling?
Yes, she graduated from Kaiser College. My daughter is a professional nurse that works very hard.
And what type of nurse is she?
She's an RN, first respond, travel nurse.
I know
And
that's right, Mama.
do you have other grandchildren through your daughter, Jamie King?
Yes, I do.
And how many grandchildren through Ms. King do you have?
I have 3.
Now, in addition to yourself, can you tell His Honor what other family members Mr. Demons, Jamell Demons, has in the state of Florida and where they would be in Florida as best you can?
He has his great grandmother, which is Justine Demons. He has an uncle, which is AJ Harris. He has a auntie that lives in Stewart, which is Tangi Anderson. He has a gang of cousins.
Don't say gang, grandmama.
And they live in the state of Florida.
Yes,
Does he have relatives also in Broward County, that being the Fort Lauderdale area?
yes, Darrell Newman.
Now, after raising him and spending time in Vero Beach, did you continue to remain close with Mr. Demons?
Yes, I did.
And how often would you see him and spend time with him?
Quite often. Sometime when his mother worked, I would take him to work with me, and he was a good kid. He just played with his little toys and stuff. I would give him something to eat. Sometimes some of my coworkers would also check on him, and he was just a good kid, coloring or playing with his little willies.
Now, up until his arrest, did you remain close with him?
Yes,
So I want to ask you some questions that are important for the reasons that we're here today.
yes,
You know that he got into the music business in his teens, correct?
yes,
Okay. To the best of your knowledge, did Mr. Demons, Jamell Demons, your grandson, ever get a driver's license?
no,
Did your grandson ever get a passport to leave the United States?
no,
And so he has no driver's license and no passport, correct?
that is correct.
All right. Now, when you remember that he, in 2019, was arrested, do you remember that?
Yes,
And you know that he has been in custody now for 7 years.
yes,
I want to talk about the contact that you've had with him since 2019. Okay, is that fair? Can we do that?
yes,
Before his arrest, would it be fair to say that you spent a lot of time with him?
yes, I did.
Okay, and as far as you know, all the other family members spent a lot of time with him.
Not every last one of them.
But
a
which
few
ones?
of them.
Which ones did he spend the most time with?
He spent the most time with me, his grandmother Justine, his mom, his brother, and his sister.
And what about his great grandmother?
Yes, Justine.
Oh, okay. Now, after he was arrested in 2019, did you, as best you could, were you able to at first keep in contact with him?
Yes,
What were the methods by which you kept in contact with him?
I would write him.
Okay. Did you have any physical meetings with him while he was in custody?
I only got a chance to visit him a few times, and then everything just came to a complete stop. No communication at all.
And when you said a complete stop, you were prohibited from person-to-person meetings with him?
Yes, we couldn't go visit him. He wasn't receiving any mail.
No telephone contact?
No phone contact. I recently wrote my grandson, here's the card, return to sender.
And you sent that to him at the,
Now let me tell you something. She's a great witness so far. She giving us just a little sass. You can tell she is definitely angry about how they have done her grandson. And based on the relationship that she has expressed to us so far, rightfully so. What did she say? Return to sender. I know that's right, Grandma.
the jail.
Yes,
And to the best of your knowledge, other family members, did they try sending him letters as well?
yes,
And did their letters get sent back similarly to yours?
Sorry. Hey, Heather. Hey, Shaniqua.
I can't answer that because I don't know for sure.
Okay, thank you. Now, has it been difficult for you at least to
Hey, Brianna.
not have physical, telephone, even written correspondence contact
Yes.
with your grandson?
Yes, it broke my heart not being able to communicate, not knowing where his mental mind is, just to hear his voice. Yes, it was very difficult.
Now, I neglected to ask you, you're full-time employed?
Yes, I am.
And what type of work do you do, ma'am?
I am a deli clerk at Publix.
Okay, how long have you been with them?
11 years.
Okay, good for you. Now, we're asking His Honor to release
Thank you for becoming a member, La Panda. And good morning.
Mr. Demons, your grandson, under whatever conditions the court deems best between now and the time of his trial. If His Honor grants that request, do you feel confident that you at least will be there to physically support, emotionally support, psychologically support your grandson?
Yes,
And have you had the opportunity to talk to other other relatives, such as his great grandmother and some of the cousins and uncles and aunts that you mentioned?
yes,
Is it your understanding that if His Honor allows Mr. Demons a release pending his trial, that the other family members will support him throughout that period of time?
yes,
Okay. Is it your understanding that the family members will do their best as loved ones to make sure that he honors the terms and conditions, whatever they may be, as set forth by His Honor?
yes.
Just 1 second. 1 second, Your Honor.
Yeah, I was trying not to stop it, but y'all just showed out. Thank you, Heather, for becoming a member. Thank you, LaPanda. Thank you, Laura, for gifting 5 Millionaire Mail memberships. And y'all know the drill. If you receive a membership from anyone today, please be sure to say thank you in the chat, because we act like we have manners around here. Thank you.
Ma'am, I know that when he was first born, you all were in Ohio and then you immediately moved to Florida, correct?
Not immediately, but shortly.
Okay. After a couple of years?
Yes.
Okay. And based on the fact that I've had time to speak to you before, other than that, to your knowledge, Mr. Demons has never lived anywhere outside the state of Florida, correct?
Never.
Okay. And his living would have been Vero Beach area and also right before his arrest, the Broward County area, correct?
Yes.
But again, other than when he was a little baby, never lived anywhere outside the state of Florida.
Yes.
That's all, Your Honor.
Any cross-examination?
No questions from the state, Your Honor.
And you may sit down.
Thank you.
While she's doing that, when you're ready, you may call your name.
Yes, Your Honor. 1 second. Nikia Mirhadi.
I know that's right, Bray. You better come in and shut it down. Good morning, Bray. Good morning.
Should we tell the truth, whole truth, nothing but the truth? Please be seated. And once you are seated, I get you to scoot that chair forward. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
My full name is Nikia Mirhadi. First name is Nikaya. Last name Mirhadi Mirhadi hyphen PATHON.
Can you do the first part of your last name?
Mirhadi MIRHADI.
And then hyphen PATHON.
Yes.
Are you ready?
Thank you. Ma'am, can you please identify what your employment is?
I am the general manager of 100K Management.
And where are you physically located with 100K Management?
I reside in Queens, New York, and we work remote.
Okay. And where are the physical locations of 100K Management?
In Broward County, Florida.
Okay. Can you describe to His Honor what 100K Management is?
So we are the management company for artists and recording artists. We also have athletes and ventured into production as well. But we pretty much assist in guiding the careers of our artists.
Okay. And can you explain to His Honor what a management company is?
So management, we pretty much just help, like I said, manage the career of artists. We help with branding, attending deals for our artists, making sure that delivery of product is always on time to their respective labels. And we also assist in some personal life well, but mostly with their careers.
And now, when did you first start with the 100K management?
So I first started in 2020 as an intern, and then I officially became the general manager in January of last year, 2025.
Now, to be clear with His Honor, you never met Mr. Demons, correct?
No, sir.
At the request of the defense, did you, however, as general manager, review the employment records of Mr. Demons?
Yes, I have reviewed all records.
And as general manager, even though you've never met him and he's been incarcerated for more than 7 years, he continues to be a client of 100K management, correct?
Yes.
And so you've actually been managing his work, having never met him.
Yes.
If you'd be so kind as to explain what it means to be managing someone who's actually incarcerated.
It's a little bit difficult. We obviously don't have a lot of contact or any contact really, so a lot of the decisions are based on what is best for our client, and just making sure that we make the best decisions and make sure that things are handed in on time to help assist in furthering his career with what we have.
Okay. Now, from reviewing his records, when did he first become a client of 100K management?
2017, and then he signed with management.
Okay. And from reviewing his records, were you able to determine, so you can explain to the court?
Good morning, Shay, and thank you so much for gifting 5 Millionaire Male memberships. And of course, if anyone receives a membership from Shay, please be sure to say thank you in the chat. Thank you, Shay, and happy Monday.
Was he somebody that fulfilled his obligations? In other words, if he was required to write music, perform music, record music, was he meeting those expectations, or was he a lazy employee? If you could just explain to His Honor what you've been able to determine from reviewing his work records.
Yes, I was able to determine that everything was handed in on time. Everything was, regularly processed, no issues. If there was a request asked of Mr. Demons, it was always fulfilled in a timely manner. And from my records, I have no issues.
Now, for the court's understanding, you're a management company. Does he have a label?
Yes, he does.
And who would that be?
300 Entertainment.
Okay. And is that a division of a major corporation?
Yes.
And who is that? Who is 300 a division of?
Atlantic Music Group.
Okay. Would it be fair to say that's a huge corporation?
Yes.
And is Mr. Demons still under that label?
Yes.
Okay. Now, what is the difference, so His Honor can understand, and all of us, between a management company and a label? What does the label do?
So label is really more on the distribution of the music, and sometimes funding of the music, but management is a lot more hands-on. We help with, sometimes the creation, whether that's setting up studio, we work on clearances, we work on, obtaining features for artists, things like that. And then, as I said earlier, also just helping with the branding of the products and the branding of the artist as well.
Okay. And does the label continue to maintain its relationship after 7 years with Mr. Demons?
Yes.
And without getting too specific about all the different music he's done, let me go back and ask this. When Mr. Demons recorded music, and if he makes bond and continues to record music, is it fair to say that these corporate entities vet the music that's released?
Yes, we always vet everything that is released. There's a pretty lengthy process. There's listening meetings, as I said, there's clearances, so we really have to make sure and go through everything to make sure that everything is essentially kosher to be released to the public.
And that's lyrical as well, correct?
Yes.
So it is vetted by transactional people, whether it be lawyers or executives, review the music of Mr. Demons then, and that would be now as well, correct?
Yes, all of the above.
Okay.
Lawyers, legal, everything.
Okay, and what I'm trying to be clear, we hear a lot of cases in these courtrooms. This is very different than 3 guys renting out a studio and just writing songs. Correct.
Yes,
This
it's
is very
different.
corporate
Yes,
focused.
yeah.
Okay.
Yeah, my artist is
Now,
my client is
do you, is it your understanding that you understand why we're here? We're seeking the court to issue an order to establish certain conditions under which Mr. Demons can be released on bond before his trial. You understand that, correct?
Yes.
Okay. And so, Your Honor, we've been in contact with the state about an address that he would stay at if he made bond. And the state agrees with us that we should not publish that address. We'll have another witness get to it, and we're happy to approach at some point. We've agreed via email to just sidebar and give that information, Your Honor. There'll be another witness. Our 5th witness will talk about his inspection, but he's been told not to reveal the name, the address.
Understood.
Thank you, Your Honor. So does the company own a home, and please don't talk about the address, in Broward County that they're prepared to let Mr. Demons stay in should he be released on bond?
Yes, sir.
And is there a
that's
recording
right.
studio built into the home that he can do work?
Yes.
And is it your understanding that if he is released on bond, under whatever conditions the court sets forth, that he will, from your side and the label side, be expected to produce work?
Yes.
And based on what you viewed before, do you see anything that would indicate that there would be any problems with that in terms of him meeting expectations?
Nothing right now.
We'll be later asking the court in our conditions of release that he be prohibited from social media. And we understand that's even more important now than ever. Would he still be able to fulfill his work requirements if he's prohibited from using social media?
Yes, he would, yeah.
Just 1 second, Your Honor. That's all, Your Honor.
State cross-examination.
No questions from the state, Your Honor.
Any reset that? Thank you very much. Thank you. Next, when you're ready, you may call your next.
Your Honor, as you know from reviewing the motion for the author hearing and bond, we've kind of set out separate things. So at this time, we would like to move to the issue regarding the conditions of confinement.
Oh, I can't remember this lady's name. I have to find it. I like her though. I saw when she went before the Supreme Court. I like her.
Understood. Go ahead.
And I would call Major Corbett.
Sir, if I could have you step all the way up to the witness stand when you read it, or you have a seat. So you tell the truth, whole truth, nothing but the truth. Yes, sir. Please be seated. So once you're seated, if I could just scoot that chair forward, you can adjust that microphone so it's pointing directly at your mouth. Will you please state your full name and spell your full name?
Yes, Your Honor. Kevin Corbett. It's Kevin Corb as in Bravo ETT. Tango Tango.
Thank you. And Major, where do you work?
Broward County Sheriff's Office, Department of Detention.
And what is your position within the Department of Detention?
I'm a major over Bureau of Investigations and Projects.
And in that position, does that make you familiar with the facilities
Yes.
and the conditions of confinement for various individuals?
Yes.
And are you familiar with sort of the normal housing for the average detainee, the visitation rules, the phone rules, those types of things?
Generally speaking, yes.
And generally speaking, how do detainees visit with family and friends?
Through a video visitation system.
So they don't leave the premises of the jail?
No.
And the friends and family don't have any personal contact?
Correct.
And what about phone contact?
Yes.
How does a detainee normally have contact with friends and family?
There's phones in the inmate housing units that they're able to utilize, if there's a financial aspect to it, whose family putting money on their accounts, but if there's money there, you can make a phone call, you can make a phone call through phones.
Okay. And in many of the dorms, do they have sort of open access to the phones to use at any time?
When they're not in lockdown. So there's certain times of day that you're not allowed out of your cell, but if for general population, yeah, normally they're just out throughout the day, and you use the phone at work.
And what about with regards to general population is the opportunity for recreation?
It's generally speaking 3 times a week.
And what does that entail?
That's an hour out to do some sort of exercise, basketball, things of that nature.
Is it in sort of a basketball court?
Yes,
Okay. And the inmates are able to play basketball with each other
correct.
as well as do other exercises and things like that?
Yes,
In addition, with regards to general population, there's interaction between the detainees.
correct.
They can play cards with each other,
Yes,
things of that nature, have conversations.
yes.
And when there are rule violations, such as disobeying an order or violating a phone privilege, like using somebody else's PIN, does BSO have sort of disciplinary rules around that?
Yes, we do.
And what is the discipline generally?
It's a disciplinary report when you are violating any of our in-house rules or regulations. It's a disciplinary report process. Long-winded, but basically it's non-violent violent, and depending on that, you can get sentenced to a certain sanctions where you're placed in confinement 23 hours a day.
And so confinement 23 hours a day is by themselves?
It's in a cell by themselves.
Okay. And then they have 1 hour that they're allowed out.
Correct.
All right. And that's for a set period of time?
Correct.
5 days, 10 days, 100
It
days?
depends on the sanctions.
Okay. What is the highest sanction? Is there a particular sanction that can go?
For disciplinary reasons, for violence, it's 30 days, but then you have consecutive, so it could go longer, they won't go corrections.
Okay. So for violent violations, it's 30 days, but if there's multiple violent, you could have 30 plus 30 plus 30.
It could go longer depending.
And for non-violent violations, what is the,
15 if I recall correctly.
okay. And it can be less depending on the violation. Okay, and those are done after a hearing
Correct. Disciplinary hearing.
where the detainee can testify, can give a statement,
Yes,
and other witnesses can give statements.
correct.
And then there's a finding by the disciplinary committee.
Correct.
And generally, how do detainees receive correspondence from family and friends?
Either through the mail or the video visitation you're speaking about.
And through the mail, are they allowed to get like birthday cards and things like that?
It's postcard driven.
So it is whatever's sort of can be written on a postcard?
Correct.
And those postcards obviously are reviewed through the sheriff's office prior to delivery.
Correct, yes.
And what about a detainee mailing out?
Same thing, postcard.
They can only mail postcards out as well?
Yeah, send postcards out, receive postcards in, unlimited.
All right. So are you familiar with Jamell Demons?
Yes, ma'am.
And Mr. Demons has been in the custody of Broward Sheriff's Office for over 7 years.
Yes.
And where is Mr. Demons currently housed?
He's in our Paul Ryan facility.
And just for the court, I'm sure knows, but for the record, how many facilities, detention facilities, does the Broward Sheriff's Office have?
3 or 4.
And do they house pre-trial detainees, all of them?
Yes.
And can you just list them?
Yes, we have a North Broward Bureau, the Paul Ryan facility we just talked about, the county facility, and the main jail bureau.
So as to the Paul Ryan facility, the current housing for Mr. Demons, I want to talk with you about that. How is he currently housed at Paul
In Paul Ryan right now, he's housed in a unit. He's in a unit by himself. Give or take a 30 cell unit with the emergency response team deputy that supervises him 24 hours a day.
Ryan? And when you talk about an emergency response deputy, they're dressed how?
Usually more tactical attire, not like what I'm guessing.
Okay. Are there any present?
Yes.
And where are
You got a couple of hoops there. Got a couple in the back of the room over there. One right over
they? Okay. And so one, and I'm not saying him, but the man standing up in the back, I'll just use as an example. A person like that is placed in the cell block with Mr. Demons.
Correct.
And are they all he's?
No.
Okay.
He or she.
Does he or she have eyes on Mr. Demons?
I mean, they're in the unit and with him, but they don't have necessarily 20. They're not in the shower with him. That's why I'm asking if you're
Okay. But they're able to otherwise see all his activities.
Yes.
And other than the deputy that is in the cell with him, are there any other deputies that come in and out of the cell?
Other supervisors that may come through on shift around things of that nature.
Other than supervisors, any other deputies?
No, it's an emergency response team detail right now.
Okay. And because there's a lot of other deputies that work in the field.
Correct.
And what about other personnel? Any other personnel
Yes.
allowed in there?
Yeah, you got nurses, mental health professionals that can come in. There's a request for like any kind of religious chaplain type thing. If you needed anybody, things of that nature, you could request any other types of services like that.
And is he allowed, but otherwise it's basically him and the ERT officer? 24 hours a day.
Correct.
So the Paul Ryan facility has 2 separate dorms on one floor.
Not 2 separate dorms. There's numerous pods, if you will, within a floor.
Okay. When I go there, there's, I think, a B and C or A and C. Or...
Okay, yeah, those are towers, but yeah, we got 2 different towers, yeah.
Okay, thank you. So there's 2 towers. Within those towers, there's multiple dorms.
Yeah, multiple housing areas or pods. Yeah.
So when I know when I come visit, there's no movement allowed in either tower while I'm there. Is that right?
Yes, when he's visiting, yes, the movement shut down.
So when Mr. Demons sees a lawyer, the tower, both towers are basically shut down.
Anywhere that he may be going, yes.
And so obviously in order to see the lawyer first, we've got to clear out the towers in order to be able to see him.
Yes.
Because he is not allowed within sight or sound of any inmate. Is that
Correct.
And that's kind of how the rule is. No sight and no sound.
Correct.
So he cannot hear another person speaking, right?
Other than people we talk about.
Right. No other detainee or other person.
Correct. Yes.
That
No
nature.
other detainee.
Can't have eyes on any other human being except for a person in uniform. And as you said, if he's had a nurse's call or something.
Yeah, medical personnel or vendors.
And likewise, nobody is allowed to see or hear him other than the people we've talked about.
Correct. Other than written correspondence. And his attorneys, of course. As you mentioned.
If they can wait till the towers are cleared, right?
Well, the grandma got her letter.
All right, so, and with regards to his recreation time, he gets to go, is it on in the
The
dorm?
recreation yard is on premises at the dorm that he's in.
Okay, so he's not taken out of the dorm for that.
No.
And again, it's basically a basketball court.
Correct.
So he's able to play basketball with himself
Yes.
and nobody else.
Correct.
So he is not allowed recreation with any other inmate or any other person.
Correct.
I assume the ERT officer doesn't play basketball
No,
with
ma'am.
him. And prior to the move to Paul Rhine, he was at the main jail.
Correct.
And was it essentially the same conditions in terms for a number of years, segregation?
He was in a housing unit by himself. It was a little different because there's adjacent housing units. So we had a little more contact in terms of seeing other inmates through the glass window, if you will, to other areas and being able to talk to them, which ways they can manipulate the system and talk to each other, unfortunately. So yes.
The thing that's so sad is he's talking about, well, yeah, he can look through a window and he can see the other inmates. This is not like an interaction that's being set up for him, but he just said they can manipulate the system to talk to each other. Why should he have to do that? Is the whole point of them having this hearing. The man, I'm all for you do a crime, you do the time, whatever, but the boy has not been convicted of anything. And he's just being isolated. I think the police, I start to believe that the police are doing this to him on purpose.
And
But
you-
it was a little bit different, but he did have a unit to himself.
Okay, and as you say, people come up with ways to communicate with each other,
Yes.
right? That is something that detention facilities deal with all over, right?
Yes.
They come up with ways when they're in segregation to send messages to each other, right?
Or anywhere, general population, it doesn't matter. They'll try to find ways to manipulate the rules.
All right. Find ways to communicate with other people, right?
I call it manipulating the rules. It's in the handbook not to do it. So.
Okay, okay. And when you discover that, you may write a disciplinary report,
Correct. Yeah, there may be sanctions.
and there may be a period of time where they're not allowed to have certain privileges,
Yes.
like visitation,
Yes.
phone privileges,
Yes.
coming out for recreation.
Correct. Yeah.
Okay. So with regards to Mr. Demons, we've talked about sort of the physical setup of how he is housed. Is he allowed to call anyone?
No.
And how long has that been since he's allowed to have phone contact with anybody on the outside world other than his lawyers?
I would repeat it. Yes, it's been a while. I have no idea how long.
If the records reflect maybe 2021,
I'll agree to that. Yeah, I have no idea. I know it's been a while.
and how about his ability to visit with family, his mom, his grandma, his great-grandma? Is he able to do any video visitation with friends or family?
No, just attorneys.
So the only people,
Why?
other than people in uniform or working for BSO, that he's allowed to speak with, video visit with, have in-person contact with are his lawyers.
Correct.
And with regards to the lack of phone privileges, visitation with anybody else, and being in segregation, again, probably around the end of 2021. Sound about accurate?
This is
It's
insane.
been a while. So I mean, whatever the record reflects.
America can be a lot of things, but you are not going to tell me that this is constitutional. You will never be able to make me feel that way.
Now, and I'm sorry, I forgot to ask this question about the lighting in the dorm, the unit, what do you call it? I'm sorry, what Mr.
Housing
Dawes,
unit.
housing unit? The lighting in the housing unit. Is he able to say, you know, I want the lights off, I'd like to sleep during the day, or?
No, it makes no control that.
Okay. And for Mr. Demons, what is the situation with the lights?
Lights in the facility go off on evening time, like normal time, we turning lights off.
which is,
I haven't worked alpha shift in a lot of years. I don't remember off the top of my head. I want to say it's after they clear head count, so probably around 11:30 at night, give or take.
so the lights are off, and when do they come back on?
In the morning after they clear, basically come in at 7 o'clock in the morning, give or take.
So, when he's brought to court, Mr. Demons able to see or hear anybody who's not in uniform?
No.
So he's brought by himself?
Correct.
He's kept in the back by himself?
Correct.
He is not allowed within to be able to hear anybody else speak, right?
That's the rule.
Or speak to anyone else.
Yes.
And is he serving a disciplinary sentence?
No.
So, I'm sure you're generally familiar with some of the disciplinary issues you've had with Mr. Demons.
Yes.
And you've had a number of issues with regards to his phone privileges,
Yes.
him using other people's pins to make phone calls, to reach other people outside, right?
Yes.
And there have been some times that he's been disciplined for that, right?
Yes. Early on, yeah.
With like 10 days lockdown or something like that.
Yes.
And he has been disciplined for being, I'm going to say, too talkative, too sociable. When he's been ordered back to his cell, he might stay out and talk with other detainees more than he's supposed to, things of that nature.
I mean, I don't know about that specific scenario, but anytime there's a rule violation, there might have been discipline.
Didn't you at one time prepare some sort of an outline?
Yeah, a couple of years ago, it's been a while.
Okay. And there may be some disciplinary reports regarding staying out of the cell, continuing a conversation with another detainee when he's ordered back in the cell.
If it's in the record, I don't remember exactly.
Okay. All right. Wouldn't surprise you. There's certainly some disciplinary issues with regards to disrespect.
Yes.
All
I
right.
remember there was some of those in there.
And I bet you have some other detainees who are disrespectful at times too.
Yes.
Officers. And Mr. Demons has been in custody 7 years, more than 7 years with BSO.
Yes.
There's times that he's been disciplined for disobeying an order, like he's ordered to stand against the wall for head count and he's looking in his cell, for example. That would be something that would be against the rules.
Yeah, not following an order of an officer, it's against the rules.
Okay. Now, do detention officials routinely do cell searches?
Yes.
And what is the purpose of the cell searches?
To ensure there's no contraband, anything that's going to hurt the safety and security of the facility.
And so I want to talk for a minute about contraband. So how about if you have an extra sweatshirt? Is that considered contraband if you were only given one?
Depending on whatever is allowed, yes, if it's excessive, that's considered contraband.
Okay, so while that's not really going to injure somebody, because it's excessive under the rule, you might be written up for contraband when it's too many pairs of socks, for example.
In general speaking, that would get you written up, it would get it confiscated.
Okay, and you might be counseled about it.
Correct.
Other things can be, too many books in the cell, because you're only allowed a certain number of books.
Correct. Excessive.
All right. And so all those things sort of fall under the contraband.
Correct.
All right. Are you aware of times that BSO detention has found in cells doing these cell searches, things like shanks,
Yes,
homemade knife type things,
yes,
weapons,
those type of weapons, yes,
and of course, those are contraband
yes,
and confiscated.
correct.
There have probably been times when you've done cell searches and found drugs in inmate cells.
Yes.
And so in 7 years, is there a set time as to how many times a cell is searched?
It's a minimum of once per shift,
Once per shift, so every day.
every day.
Okay. So, ooh, my math is terrible. 7 years at 365 days a year are all the time, so that'd be 2,100 something. Your math is no better than mine.
No.
Every day for more than 7 years, Mr. Demons' cell has been searched.
Yes,
And in all of those days, there's never been a shank found, right?
not that I know.
There's never been any kind of weaponry found.
Not that I know.
There's never been any drugs found.
Not that I know.
Okay. And with the DRs that you're generally familiar with, well, let me ask you this generally. You certainly have had detainees in BSO's custody that have gotten in fights with other detainees.
Yes,
There are some who repeatedly get in fights with other detainees, right?
yes,
And kind of the young detainees might be more likely to be involved in fighting or that type of behavior.
potentially,
Would you agree with that?
yes,
And then I imagine you've had detainees that have physically attacked officers,
yes,
including like wrestling with them or, really attacking them.
yes,
Now with Mr. Demons, when he was in custody at age 19, he did get in a fight with some other inmates, right?
I believe so, if I remember correctly.
Okay.
From the
But,
records.
but since 2019, there has not been a single time that Mr. Demons has been in a fight with other inmates, right?
Not that I recall, but that's what the record shows.
And there's not a single time while he has occasionally disobeyed orders and been disrespectful to staff, there's not a single time he has attacked any BSO officer, is there?
Not that I know.
Now, some of the rules that Mr. Demons has broken were facilitated by other deputies in the jail, right?
Correct,
And that includes the passing of notes to other inmates when he wasn't allowed to.
yes,
Might include things with regards to phone access.
correct,
And speaking of communications with other inmates, that's considered contraband as well if you have a note from another inmate in your cell.
correct.
Called kites.
Kites, yes,
Okay.
that's the slang term for it, yes.
All right, and they're found routinely in these cell searches around all of your facilities, right?
Inmates pass kites, it's not abnormal.
Now, there's been deputies involved, as I say, with Mr. Demons and some of the violations, right?
Correct,
And I'm sure there's actions taken by BSO, but they certainly aren't placed in solitary confinement, right?
no, there's disciplinary sanction, have people fired and are left under investigation, and there's active investigations.
Okay. Have they ever been told they can't talk to any family or friend for 6 years?
No.
Have they ever been told they can't see any other person except a person in uniform?
No,
Or be locked in a cell with a person in uniform for years?
no,
I think that's all I have Thank you for coming.
Yes, ma'am.
Today, cross-examination.
So, Your Honor, he is one of my witnesses, so I would be questioning him and introducing evidence. I don't know if Your Honor.
And then break.
And before I begin my cross-examination, I did want to drop off yesterday a USB with some of the documents I'm going to be introducing for this hearing, Your Honor. But defense objected, so I did not drop it off. So these are the items I'll be showing. Good morning,
Good
Major.
morning.
How are you?
Good, yourself?
I'm well, thank you. So in keeping with the discussion of Mr. Demons and his violations, let's call them, within the jail during his 7-year tenure there, I want to go over some specifics with you, okay?
Okay.
Currently, he is housed in what's called an open door cell, correct?
Correct, open door.
Open dorm. So he has the entire dorm to himself.
Correct.
He is not locked in a tiny cell.
Please, girl, I know she's not about to argue that this man has so much space. He has the entire dorm to himself, as if that makes it better.
24 hours a day with no one to talk to, correct?
Girl.
He has the ability to walk around, right?
Yes.
He has the ability to watch TV
Yes.
all day if he'd like.
Yes. I'm going outside of the normal lockdown time too.
Sure, that any inmate would be subject to.
Correct.
He has the ability to change the channel on demand, correct?
Yeah, he just has a little bit of video. Yeah.
Sure.
So because he can't watch TV, that somehow excuses the fact that the man cannot talk to anyone on the outside world except his attorneys and these damn sheriffs. Like, be for real.
Unlike other inmates who have to share a TV with other inmates in their pod, correct?
Correct.
Okay, and that TV is placed on one channel and it's unlikely that they get to decide which channel they want because there's so many people there.
Yeah, it's generally just the majority rules in that scenario.
Okay. He has no shower restrictions, correct?
Correct.
He gets to play basketball as you testified to, correct?
Correct.
He can work out on that basketball court how he sees fit, correct?
Correct.
He is allowed to have chaplain services if he's requested it.
Yes.
Has he requested it?
Not that I know of.
He sees a nurse, I think, every day, correct?
Every shift.
Every shift. So how many shifts are in a day?
3.
So he sees 3 nurses a day.
Yes.
He also sees a psychologist or a doctor once a week.
Yes, mental health professional somebody once a week.
And he is allowed in-person visits with his attorneys that are non-barrier, correct?
Correct.
He's also allowed in-person visits with his investigator on the case, correct?
Correct.
And those are
All
non-barrier as
his
well.
face.
Yes.
He's also allowed video calls with his attorneys, correct?
Yes.
He also has unlimited access to seeing a nurse or psychologist or psychiatrist, correct, if needed.
If needed, yeah. It says that.
He's also allowed to send unlimited amounts of postcards and letters to family and friends, correct?
Send and receive.
And receive. I was going to get to receive in a minute. But he's allowed to send out as many letters as he sees fit, correct?
Yes. Okay.
And within the jail, there is a process of how those are sent, correct?
Yeah, there's rules surrounding it.
And are copies made sometimes of jail mail that is sent out by defendants or inmates, I should say.
You mean copies?
Are copies kept by law enforcement, by BSO, or made if they violate potentially protocol?
Yeah, I mean, there's a specific reason to, yes.
And do you know that there were letters sent out by the defendant that were kept by BSO?
That were retained, you mean copies, yes.
And have you seen some of those in the past?
Yes.
What was he saying then?
Showing defense counsel the 3 that I sent you yesterday. I just highlighted the notes.
Yeah, I'm trying to figure out what's going on with the male leader because it kind of sounded like he has no communication. So I'm trying to see.
Their first witness, counsel.
Y'all, when is Mother's Day?
right, Major, I'm showing you what's been previously marked as dates. Exhibit 1, 2, and 3, or I should say A, B, and C.
Okay,
Can you take a look at those?
sure.
Mother's Day on Sunday for real? Or are y'all joking with me? Y'all had no clue that Mother's Day was on Sunday. Oh my God, I got to get some gifts, child. I got to get some gifts. I didn't know Mother's Day was on Sunday. I did not know Mother's Day was. Oh my God. Wow.
You mean like read the entire thing or?
Take a look at them,
Okay.
just review them.
Y'all, let me tell you, I knew it was coming up because I have been doing a lot of shopping. You know, I'm going out of town soon. So I've been doing a lot of shopping. So I knew Mother's Day was coming up because they keep giving you Mother's Day, half off, all this type of stuff. But none of it ever told me the day. Like, dang. Well, I mean, I'm going to get my gifts. I'll get them now. I didn't know that.
Okay, thank you.
Now, Major, do you recognize these?
Yes,
Okay, and are these the types of postcards that you're talking about that inmates can send out?
yes,
And do you recognize these as being ones sent by the defendant?
yes,
And were these copied and retained by BSO?
yes,
And do they appear to be in the same or substantially same condition that they were when they were copied
yes.
originally? Your Honor, at this time, the state would enter into evidence between previously marked as states A, states B, and states C.
Sure. And I do have an objection or at least an opportunity to audio the witness.
Okay, let me start with, A for identification, which is 2 pages, front, side only, defense, any objection, or if you want to, or have the witness, you may do so.
And I'm sorry, Judge, your A is what?
Looks like an Easter card.
Okay. 2 pages.
Yeah.
And yes, if I may ask a couple of questions.
Yes.
Major, there's some highlighting on that. Is that the original?
Highlights, I don't believe the highlights are the original.
Okay, and when were those cards written?
I don't remember exactly, it's probably in the wall. I mean, obviously one's around Easter, but I don't remember.
Okay. Do you know which Easter in the last 7 years that Mr. Demons has been in custody?
Probably all 7 of them he's been in custody.
Yes, I know. Which Easter card with this?
I don't know, I don't remember. It was probably maybe last year, I don't remember.
Okay, so you don't know when that card was written. And in terms of how you know it was Mr. Demons?
Because it was flagged by my team and copied, and they told me about it when it happened, so I do remember that.
Okay, in terms of your team, so you got it because a team flagged it from the mailroom?
From the mailroom or my emergency response team, one of those told me not activated.
Okay, do you know where, Mr. Demons was housed when this was written?
Either Paul Ryan or me in jail, I don't remember.
And how many times has he been at Paul Ryan?
I think this is the second trip there.
So if there's a reference to the Paul Ryan facility, that doesn't necessarily tell us when these were written, right?
No, it could be this one or the last time he was there.
Judge, we would object on relevance, foundation.
Well, number one, understanding it's a bond,
Yes.
not from insurance. It's overruled as the relevance, and as the foundation, I guess you're saying authentication, is that what you're saying? If we were in front of the jury, which we're not, that would be a pretty low bar, and state safe for identification, says, in part, I got a whole unit to myself, so that seems to authenticate where it came from, but over your objection, which is otherwise preserved, again, it's only for purposes of this hearing. At the conclusion of the evidence, I'll let each of you argue to me whatever weight I should or shouldn't put any of the evidence in this. But over the defense objection, if exhibit A for identification, which is 2 pages, is not going to be in evidence. That's state's exhibit 1. Defense as to state's exhibit B for identification, which has a card on the front that says, "I wish we could be together." Any board eye or any objection to this one?
Really the same questions, if I can do that
Sure.
quickly. Highlighting was not you, right, or BSO?
It was not me. I mean, I don't know, somebody else highlighted it, I don't believe so. I don't
You don't
highlight
know
it.
where the highlighting came from, and again, with regards to when it was written,
Same answer.
all right, whether, and you mentioned he was in Paul Ryan before, and when, do you know when that was?
I want to say last year, year before,
And then he was at the main jail for a year or two?
back to the main jail and then back to Paul Ryan.
And how long?
Earlier this year.
Okay.
I think that was like January this year.
All right, so we don't know when that was written with regards to where.
Which facility you in? I don't know.
Same objection.
Okay, so it's the same ruling, begin over defense objection as relevancy and as to authentication, which is otherwise preserved, and again, it's only for purposes of the bond motion today. B for identification is not to be evidence that states exhibit 2 as to states exhibit C for identification. Defense, this one says happy birthday. Any board eye or any issues? Defense, any questions or anything?
Same questions. Good. With regards to, is this the birthday?
Happy birthday.
Yes. With regards to the, and while these are on pieces of paper, these would just be postcards.
Postcards.
With regards to that postcard, do you know when it was written?
Same answer.
And same thing, it was brought to your attention, is that?
Yes.
Do you have copies of all, Mr. Demons? Outgoing mail?
We copy it now.
So, yes, you do have copies of all.
I mean, I don't know where, if you have retained all of it in terms of BSO having it right now, but at some point, we copied his mail for a while.
Okay, so the fact that there's 3 here, you've actually copied any correspondence he sent out.
Not legal,
I'm sorry.
not legal, not privileged.
Right. But to any family or friends.
The rest of the mail, yes, we've been counting, I think for a while we were not, but we recently started it.
Okay. And does it sound right that he was moved to Paul Ryan the first time right at around Easter of 24?
Whatever the record reflects, I don't remember.
Same objection.
Okay, same one, in the defense objection. See for identification, not to be in evidence as states exhibit 3. You may proceed.
Thank you, Judge. All right, so Major, in these postcards that were just entered into evidence, I'll show you states. One first. If you could just read me the highlighted portion.
Sure. They moved me to another jail. It's way better here. I get a whole unit to myself. I'm out all day and I got a rec yard, personal indoor basketball court all to myself. It's like a mansion. They treat me way better here. Food is better. I don't have a cell. It's open day and I watch TV.
Now, let me just say, a letter like this, granted, he can't see his family. We know that. But what the state is trying to prove, oh, he's good. These are better conditions. This letter just adds to their case, and I hate that.
All day. Just something. Just me and God.
Oh, I hate that letter.
Showing you states 2 in evidence. You could read me the highlighted portion.
So, they moved me to another jail. I don't curse.
You won't be cursing, you're just reading what's
I
in
don't.
evidence.
So SHIT, can I spell it?
Sure.
Thank you. Way better food. I got a whole unit to myself with a basketball court, TV all day, the same S word. This be like a mini mansion via. I can walk around all day, and same S word. I wish in the box. Well, they call me mailman, so I call it a mailbox.
That's what it sounds like, Brianna, and I hate this one.
I'm showing you states 3. You could just read that highlighted portion.
Oh yeah, they moved me to a way better jail. I explained it in the letter to Michelle. I can't read this. Michelle, read into you. I think it says Marshall read. Michelle read into you.
Thank you so much.
Yes, ma'am.
Now, you indicated that the defendant has been moved to Paul Ryan, you think twice, correct?
Yes,
And each time he's been moved to Paul Ryan, it's been the exact same setup.
correct.
So again, it's the pod to himself, dorm to himself, open cell, TV, all of that we've discussed.
Yes, and basically treated as a general population inmate in terms of the rights and privileges that he has while he's there.
And in addition to being able to send postcards whenever he wants, he can receive fan mail, correct?
Yes,
And he does in fact receive all of his fan mail.
correct, yeah.
And in order to receive mail, they have to just have the correct address to send it to, correct?
Correct.
So if mail doesn't arrive to the inmate, it could be because they didn't have the correct address.
Either correct address or the mail, it's not a postcard, or maybe something wrong with the postcard, it's manipulated, things of that nature. It has a certain standard it needs to meet. As long as it meets the standard, he'll get it.
And certain mail doesn't get to an inmate sometimes because improper things are sent to him.
Correct.
With any inmate in the BSO jail, if there are any violations, those are documented, correct?
Correct.
Any interaction with an inmate is documented through what's called, I think, a contact log.
Correct, contact log.
All right. And not only just disciplinary actions or discussions are documented, but any sort of safety and security concerns are also documented, correct?
Correct.
Showing defense counsel has been previously marked as states D for identification. May I approach the witness, Your Honor? Major, I'm showing you what's been previously marked as states D for identification purposes. If you could just take a look at that for me, please.
Okay.
I was like, it's too quiet. He was like he's reading over something.
Yes, this is the contact log report I used when I wrote a memo a couple years ago.
We're gonna get to the memo in a minute, but this contact log is the type of contact log that's kept for any inmate in the Broward County Sheriff's Jail.
Every single day, yes.
And is this the contact log for the defendant?
Yes,
And does it fairly and accurately represent the way that the records are kept for BSO?
correct, yes.
Your Honor, at this time, the state would enter into evidence that's been previously marked as state D for identification.
Well, just I brought here just on this. So this is the contact log for Mr. Demons.
Yes,
Mr. Demons is currently in custody, right?
yes.
And the date today is
April
Cheat,
30th, 2026.
2026, and that contact log goes through, I believe, November
24.
of 24. So it really doesn't contain anything
Recent.
since then.
Not recent, no.
Okay, and it contains sort of any contact, so it can be all inmates were given the opportunity to take medication, things of that nature, right?
Correct.
So Judge, I would object on relevance, and you don't maintain this contact log, is that right?
No, the staff that work there, in terms of who documents into it, that's a staff working where Demon's house.
So I would object on relevance, and I know the rules are different for bond hearings, but it has so much irrelevant information that I would submit the weight of that document. It's irrelevant to the issues at hand.
Okay, so, again, I'll let y'all argue at the end of the day. What you think each of these things should be, but over the defense objection, the identification and the evidence that states exhibit 4. Then proceed.
Now, Major, you mentioned a timeline that you actually made yourself, correct?
Correct.
And what is that timeline of?
That was a timeline of events that kind of led up to why he's been under the restrictions he's under, in terms of the way he's housed, which is not normal for generally speaking or other inmates. But it's pretty much a timeline of everything he's done while in our custody up until that point that led to where he was in terms of, like I said, housing and restrictions.
Showing defense counsel with some previously marked as states E for identification. May I approach the witness? Major, if you could take a look, it states E for identification purposes.
Yes, this is documented post.
And does this document, this timeline that we're talking about, fairly and accurately represent much of the defendant's conduct and or his prior attorney's conduct and situations that led him to his first visit to Paul Ryan?
Yes.
Okay. So this would be up until, and I just want to get the date correct, I believe September of 2024.
Yes.
And does this timeline fairly and accurately represent your review of all of the records leading up to that time of the defendant's actions in this document?
Yes.
Your Honor, at this time, the state would enter into evidence which when previously marked as states E as states 5.
Just a quick voir dire, Judge. Major Corbett, everything contained in this summary is contained in the contact log?
I don't know if everything is, as I have information from different sources at the time in terms of the incident reports written or the contact card, but much of it came from the contact log.
Thank you.
Yes.
So Judge, 2 objections. One, there's an affidavit that I would submit is not admissible on the end of it. The witness is here, the witness is testifying about the record. So.
Yeah, the last 2 pages, you want the affidavit off?
Yes.
Yeah, I agree with it here, so I don't need that. So we'll amend the exhibit. Besides that, any additional fixes?
Just to the extent it duplicates the multi-page contact report, I would just.
So otherwise, over the defense objection, I'm going to take, I guess we'll call the amendment states to e-identification, states to the five bucket. Can you take off the last 2 pages?
Sure.
Put a new sticker, which identifies a state for identification, and now that's going to be written in school constitution states to the crime.
All right, Major. You have states 5 in your hand, and I want to go through some of the pertinent portions of this timeline and events that led the defendant to be housed at the Paul Ryan facility the first time.
Okay.
So can you tell me what occurred within the first 30 days of the defendant's incarceration?
During his first 30 days, YNW Demons was violating jail facility rules and regulations, and that began a continuous escalating pattern of behavior and conduct, which jeopardized the safety and security of DSO detention facilities. At that time, he was charged with additional criminal offenses of tampering with a witness in capital proceeding, conspiracy to commit tampering, solicitation to commit tampering, and a plan to direct criminal gang activities. And that was between the dates of April 10, 2023 and July 22nd, 2023.
What occurred on March 13th of 2019?
March 13th, he was issued a disciplinary report for violations of constitutional distrust, unauthorized phone use, and unauthorized phone act. As it was discovered that he initiated communication with his co-defendant, Henry Cortland, via a 3-way call. And the jail security cameras verified that both inmates were present in their respective housing units, communicating on the phone at that time. And he was found guilty of all charges, received 30 days of confinement.
So when you say 3-way communication call, those are not permitted within the jail, correct?
Correct.
And defendants, inmates are made aware of that, correct?
Correct.
Is that in the handbook they received?
Yes.
And that's especially not permitted when it comes to co-defendants, correct?
Correct.
And so in that particular violation, he received a 30-day sentence
Correct.
and lost some privileges.
Yes.
At that point, he was not confined to, Paul Ryan at that point.
Correct.
I'll loop March 17th, 18th, and 18th together. What were those violations for?
During cell inspection, he wasn't complying with staff directions.
Okay. What about March 29th of 2019?
He was violating regarding his phone restrictions. His privileges were restricted to attorney calls only from March 29th to April 12th. And during that time frame, there were a total of 24 calls made from his unique PIN. But he was also having other people portray themselves as himself and call on his behalf. And at the time, he also had a civilian put money onto another female's phone at that time. And he participated in violation by initiating a call with his unique PIN and having his voice verified before the calls could be placed.
So when you say having his voice verified before the call can be placed, what does that mean?
You have to have voice recognition to be able to use the voice recognition on a phone system. So he was able to basically verify, like, hey, this is me talking to them, allow other people to communicate that should now be communicating on a phone call.
So each inmate is assigned his own PIN, correct?
Correct.
With their specific voice,
Correct. Voice biometric.
and no other individual is permitted to use that particular PIN,
Correct.
but he was violating that.
Correct.
April 4th of 2019, he received a 2-hour room restriction due to disorderly conduct.
Yes.
April 8th of 2019, he was just counseled, correct, for walking around the unit and talking to other inmates instead of returning to his cell, correct?
Yes.
And he also lied to staff?
Yes, he lied to staff and asked if he was on a video visitation. He confirmed. The visit had concluded. Later in the same shift, he was again counseled for the same behavior. As the second video visitation concluded, he went to the phone, made phone calls instead of returning to his cell he was supposed to.
May 2nd of 2019, he was observed banging on the window or door, correct?
Correct.
May 7th of 2019, he was being loud and disruptive during lockdown, correct?
Correct.
May 10th of 2019, he was disrespectful towards staff and banging on the wall and window during head count, correct?
Correct.
And when a deputy addressed him, he responded, "I don't give a f-."
Correct.
May 11th of 2019, he also received another 2-hour room restriction for hiding in the shower and refusing to go back to his room during lockdown, correct?
Correct.
I hope his attorneys point out how young this boy was when all of this happened. He was literally a teenager. I will point that out here. He's in a new environment. He's being charged. He's charged with murder. He's never been in these type of conditions before. I will be pointing it out with him. That's how I would go up against everything she's doing right now. This is all they said. This is 2019. This is when he first got there.
May 13th of 2019, he said some inappropriate comments to a female deputy as she walked through the dorm, correct?
Correct.
During May and June of 2019, he's counseled many times and put on 2-hour room restrictions for talking to other inmates when he's not supposed to, or being loud or disruptive and banging on doors, correct?
Correct.
Again, on June 24th, 2019, he was counseled for disrespect towards staff, including stating to a female deputy some other inappropriate words.
Correct.
June 30th, 2019, was he also placed on another 2-hour room restriction for lying to the deputy, stating that he had another video visitation during lockdown.
Correct.
July of 2019, again, counseled because he was kicking and banging his door, correct?
Yes.
Some other violations through July regarding horseplay and not returning to his room, correct?
Yes, and passing those he shouldn't be passing under doors, under security doors.
He also was placed on another 2-hour room restriction on July 12th, 2019 for disrespecting staff by using obscene language, again, correct?
Yes.
July 15th, 2019, he was placed on a 2-hour room restriction for refusing to get up for school.
Yes.
July 18th, 2019, he, along with other inmates, refused to go to their cells in a timely manner, correct?
Correct.
And was he, on July 19th, 2019, which is now on the 3rd page, did he receive a DR?
Yes, for threatening another, refusing to obey an order.
Okay, and when you say threatening another, who was he threatening?
He was threatening the deputy.
Okay. So while you were questioned if he ever actually physically attacked a deputy, and you said no, he has in fact threatened deputies with violence.
Correct.
And for the record, on July 19th, 2019, after being disrespectful and saying, he then pushed the deputy's hand away and said, "Don't touch me, you don't know who I am. I'll have my people take care of you in the streets."
Correct.
And he received 20 days of disciplinary confinement during that time, correct?
Correct.
And also 10 days of probation.
Yes.
And he received a hearing that was talked about on direct examination, correct? Where he can testify.
Correct.
And he said, "I'm a celebrity and
I understand everything the state is trying to do, but like Ms. Jones just said, he was 19 at the time. Not only was he 19, this boy was a celebrity. He was out living his life, making money, regardless of how you may feel about whether he did the crime or not. This was his normal. He was a celebrity who had to turn himself in at 19 years old. He gets to this jail. I would be mad as hell too. You know, these kids thrive off social media, popularity. He had it all. He had it all, and it was taken away. The boy's in jail, literally angry. He went from doing whatever, doing shows, making money, to just being in this cell. I would be mad as hell too. I'd expect him to act like this at 19.
Don't want inmates in my face, and asked if he could go to the 8th floor so he can not have inmates near him.
Correct.
August 9th of 2019, he had contraband.
I'm sorry, I just am gonna object to it. Are we gonna read through each one, please?
I can read these. And, no, it's all right.
Allow-
Gee.
I'm gonna read everything. Go ahead.
Sure, Judge.
It's been so
Throughout 2019, the defendant had numerous violations that eventually led him to different confinements, correct?
Correct.
And despite the numerous 20-day, 30-day confinements, he still would violate, correct?
Yes, and there were restrictions, yes.
And you mentioned how he had numerous violations for passing those letters, or what we call kites, correct?
Correct.
And how would he pass those kites?
Either through other inmates or under doors, under security doors in between units, you could attach from one unit to the next, or stop it under another inmate's cell door, or have other inmates pass it for you.
So at one point, the defendant was in fact put into I think I'm saying this correctly, a dorm where each individual is only let out for 1 hour a day within the main jail, correct?
Correct, yeah, segregation, yeah.
Segregation, but there are still other inmates around him in those other cells.
Correct, yes.
And it's common that these inmates will talk to each other despite being in segregation through the walls.
Correct.
It's also common that when an inmate's out for their 1 hour a day, they're going up to the other inmates' windows of their doors to talk to them, correct?
They should not be, but sometimes that happens, yes.
And Mr. Demons has been seen on video actually doing such as that, correct?
Yes,
Okay, and you mentioned that you saw on video the defendant passing some of what we call kites under his door and or the wall doors of the jail, correct?
correct,
And some of these kites have in fact been collected.
correct.
Showing defense counsel with some previously marked as states, I think I'm on 6, or states F, sorry. To defense counsel.
yeah, but I don't want to picture it. I don't want to picture that because I feel you probably were doing too much in that max. Yeah, but I didn't know who he was until he
First witness, Your Honor.
I had to ask Mariah, who is this boy that was arrested for?
Major, I'm now showing you what's been previously marked as states F for identification, if you could take a look at it.
Okay.
Do you recognize it?
Yes,
And what is it?
it's a kite.
A kite of whose?
That's a kite of defendant.
Okay, and these are just one of the many kites that was found to be shoved under his door or one of the jail walls?
Correct.
Okay, and are these kites, when they're located by the Broward Sheriff's Office, kept as part of your investigation?
Correct.
And does this fairly and accurately represent one of those kites that was found?
Yes.
Your Honor, at this time, the state would enter into evidence that's been previously marked as states F and state 6.
Okay, any objection?
Yes. And if I could briefly voir dire. Do you know when that was written?
Don't know the exact date.
Do you know where it was found?
By my staff, I don't remember exactly where.
So you don't know whose cell, or if it was even found in Mr. Demons?
I have to go back to the documentation, I don't remember, but I know it was his because my team told me about it immediately.
Okay, so not something you have personal knowledge of, and you don't know when it was written or where it was found. Right?
Correct, it's in the record somewhere, I'm sure, but off the top of my head.
Whoops.
Sorry.
Same objection, Judge.
All right, again, it's just a bottom, over the defense objection. States F identification, not any evidence that states Exhibit 6.
Now, Major, the defendant not only just violated rules and procedure of BSO, but he also presented as a security risk, correct?
Correct.
Okay. And there were numerous reasons why he was presenting as a security risk, correct?
Yes.
And in this particular kite states 6 that he sent under his door or one of the walls. The portion I want to talk about is I should get a burner number from my lawyer today. When I do, bam, don't ever call that bit without your PIN, exclamation point, exclamation point, exclamation point. So when you see burner number, does that indicate to BSO that there is a potential security risk there?
Absolutely.
Okay. And are inmates allowed to have cell phones?
No.
Okay. Have inmates been caught with cell phones before?
Yes.
Is that a security risk?
Absolutely.
Why is it a security risk?
They can facilitate either criminal behavior outside of the facility when they have unrestricted phone access like that that's not monitored, or they can coordinate some sort of attack, some sort of potential escape plan, things of that nature, without us being able to get triggered to it because they're not using the phone system like they should be.
And during the defendant's tenure that we've talked about with the jail here, there have actually been some deputies, technicians, and nurses who have been terminated for their assistance with the defendant in doing things he's not supposed to do, correct?
Correct.
Can you tell the judge some of those incidents?
There's one incident where a deputy and a deputy and a tech that were providing the defendant some printed material they should not be providing him. That got them under investigation for giving him things they shouldn't be giving him. And if I recall correctly, the deputy, while under investigation, resigned, and the detention technician ultimately got fired. Another instance was a nurse when he was in Paul Ryan the first time. A nurse ended up getting a note or passing a note to him, trying to get him to call her. So she was trying to start some sort of relationship. I don't know what exactly. That got her fired. And then more recently, we've had a active investigation where a staff member is under investigation for providing him with potential access to telecommunication devices.
We're going to get to that in a minute. So still sticking with the first time he was brought to Paul Ryan, right? He eventually was brought back to the main jail and put in one of those dorms we talked about where he's in a cell with other people around him, correct?
He's in his own unit, but there's a unit adjacent to him that has numerous inmates in there.
Sure. And again, was still talking through the walls to other inmates, correct?
Correct, yeah, under the door, through the walls, etc.
And then, as you mentioned just now, most recently, there's been another incident that is now under investigation, correct?
Correct.
Okay. And were you made aware of a video that went viral of the defendant using a cell phone to FaceTime from his jail cell?
Yes.
And you've seen that video, correct?
Yes.
Alice, you just talked about that video.
States showing defense counsel stage G for identification purposes.
And whoever leaked that, knowing what this boy's going through,
Well, you can look at it on your computer if you want.
kids get on my nerves.
May I approach the witness, Your Honor? Showing you what's been marked as case G for identification purposes. You had a chance to review this right before you testified today, correct?
Yes.
Okay. And what is it?
It's a video of Demons on a cell phone while another person is on a cell phone FaceTiming while they're at the basketball team at an NBA game.
Okay. And the video that you watched today was a clip of that particular video online, correct?
Correct.
Okay. And that was
In this person's defense, this video, someone was recording them, and I don't believe they knew they were being recorded. But it's literally like, if you are in a space with anyone who is young and keeps up with hip hop, please go somewhere else because they're going to record it. They're going to record it.
of January of this year, correct?
Correct.
Okay. And this video that you watched this morning accurately depicts that video that went viral all
Aaron, what's so funny is when I hit mute, I was like, I'd be saying this AI.
over the internet back in January, correct?
Yes.
Your Honor, at this time, this state would enter into evidence that's been previously marked as case GS867.
Yes, sir. Thank you. So, Major, you reviewed that.
Yes.
Are you familiar with AI?
Not so much. I know it exists.
Okay.
I know that's
Are
right,
you
girl.
aware that AI has the ability to replicate people?
If you say so.
And there's been people who've said that's
I
not
know
me.
that's right.
That was AI, right? In fact, our president has said that a
I've
number
heard
of
of that
times.
happening. Again, I don't know the technology will.
Stop it.
Okay, and in terms of this video, you have no way of knowing whether this was true or created by AI.
I'm not a video expert, ma'am.
Okay. I'm not either, so if I can have them.
I actually say, did you authenticate it?
And in terms of BSO, any effort to employ a third-party engineering firm to make that determination as to whether it's real or whether it's AI?
I don't know. It's an active investigation. Can't answer that.
So Judge, I would object to this in terms of it being
Come on, ma'am.
accurate.
Yes, ma'am.
I mean, again, be different from the jury, but it's just a mind. So argue it again, and then we should put in, don't do a defense objection. Otherwise, you've heard identification found to be evidence, that's exhibit 7.
Judge, I'm not going to publish it. Your Honor has it to review. Now, Major, you've watched this video, and you testified earlier that he's only allowed video visitation with certain individuals, correct?
Correct, as attorneys.
And the woman that's on this video FaceTiming with the defendant in January of 2026 is not one of those individuals, correct?
Correct.
Now, you mentioned an active investigation, but there are portions that are out there, correct?
Yes.
And isn't it true that the deputy assigned to Mr. Demons during that time was in fact arrested for bringing the defendant a cell phone?
Correct.
Action on relevance.
Well,
I know.
that's overruled. Testimony presented about his behavior in jail. I'm not sure how much of that issue matters to me, but it was brought up on direct. So go ahead, sir. You can answer that question.
Yes.
And once it was figured out that this deputy brought the defendant a cell phone, and when you saw the video online, was a cell search done of the defendant's cell.
Yes.
And were numerous cell phone chargers found within his cell.
Yes.
So is it because of the defendant's behavior, thousands of violations that are within those documents that have been presented and are in evidence, that he has now been brought back to the Paul Ryan facility because of his own actions?
Correct, and put back under ERT watch as well as we go through that.
Okay. One moment, Your Honor. No further questions, Your Honor.
Based on that, we redirect.
Just a little bit.
Go ahead.
And sir, this is not a hearing about whether BSO is doing right or wrong, right? And it just is regarding Mr. Demons' day-to-day living conditions. Correct? You talked initially in great detail about Mr. Demons' first couple of months in custody. He was 19 years old, right?
Yeah.
And I'm sure you, in your experience, have seen that often inmates have a lot of difficulty with the initial adjustment of incarceration, right?
Depends on the person.
Come on, girl.
You've seen that. And you've seen it especially with younger.
Yes, ma'am.
Younger inmates tend to be more problematic.
Okay. You mentioned specifically contact with Mr. Henry, his co-defendant.
Yes.
Are you aware that Mr. Demons and Mr. Henry are longtime friends?
I don't know much about him.
I'm sure what you are aware of is, with your involvement with detention, is that friends try to contact each other in custody even when they're not supposed to, right?
Yeah, that's why we have rules in place.
I know, but they still break the rules to do it, don't they?
They will, potentially.
You talked about the issue of letting other people use his PIN. It costs money for a detainee to be able to call people, right?
Correct.
So if they don't have money, if they're poor, they're not able to call friends and family, right? Because they don't have a PIN, they can't afford it.
Correct. Oh, they have a PIN, they just don't.
They don't have any money
on
on it.
call.
So using somebody else's PIN who does have some money on it, that way they can make a call, right?
They could, but it's violating the rules.
Sure, understood. Passing kites, that was at times with assistance of BSO employees.
Yes.
The burner phone that you mentioned, and cell phones are a real problem for corrections staff these days, aren't they?
It's a concern.
It's in both local jails and the state prison system.
Yes.
And as you say, it can be a security risk,
Absolutely.
right? But it also can be a way that people can contact their family and friends for less money than what might be charged at a facility or an institution, right?
I mean, I don't know how much they would be charged to get a cell phone in, so I can't answer that.
But you do know they charge every time to make a call from the jail,
Yes.
right? And
There's
same with
a
our,
fee to make phone calls, yes.
same with our prison system.
Yeah, I'm sure it is the same. I have no idea. I work with the person.
So, the issue about a deputy giving, Mr. Demons papers that were not allowed, they were photographs of his girlfriend, right?
I couldn't remember exactly what they were, but yeah.
Okay. Just
That's what the
photographs.
records reflected.
Okay. They weren't seen photographs, right? They were just photographs that he wasn't supposed to have because you're not allowed to have photographs, right?
Well, you can have photographs, but that's what getting it from a deputy printed off of a printer.
Understood. And the issue with the deputy being provided, the deputy who provided him a phone that you believe had to do with the chargers in the cell. Mr. Demons wasn't charged with any, didn't receive any kind of disciplinary report from that incident, did he?
I don't remember if we did or not.
Let me just ask you this, sir.
Yes.
You did go through the conditions. So he's, as you said, Mr. Demons is in a big cell, and he made reference to that in his letter, right?
Yeah, a large unit.
Yeah, by himself, right?
That's with an ERT deputy.
And in the letters where he says, this is so much better, it's always, in all three of those exhibits, it's always termed as way better than where he was.
I like her.
That's what it said, yes.
Great
So
point.
way better than where he was is being all by himself, sitting in a big cell now with one ERT officer and no contact with his friends, his family, anything, right?
Correct.
And that was way better when he got moved to Paul Line than where he had been.
That's what he said, yes.
Have you ever been in a big room by yourself with nobody and not allowed to talk to anybody and not allowed to see anybody?
No.
And certainly not for years on end.
No.
Questions?
Based on that, any response?
No, Your Honor.
Okay, defense is the witness excused.
Yes.
All right, so you may sit down, thank you very much. While you're doing that, since when you're ready, you may call your witness.
Dr. Matt Norman.
So if I gotta come all the way through the witness stand, once you reach it, you put your face down before you have a seat. And you just stop it. Raise your right hand. Swear to tell the truth, whole truth, nothing but the truth.
I do.
Please be seated. And so once you're seated, I can just scoot that chair forward as far as it will go. You can adjust that microphone so it's pointed directly to your mouth. Can you please state your full name and spell your full name?
Matthew Norman, MATTHEWNORMAN.
And sir, what do you do for a living?
I am a general and forensic psychiatrist based in Atlanta, Georgia.
Do you have any particular licenses?
I do. I'm licensed to practice medicine and surgery in the state of Georgia and have had an unrestricted license since 1998 in Georgia. I also hold unrestricted licenses in Texas, Ohio, Missouri, Nevada, and the state of Florida.
And I assume with that, you have a medical degree.
I do.
Medical school.
Yes. I completed my undergraduate work majoring in psychology at University of Virginia, graduating in 1991. I then went to medical school at Mercer University School of Medicine, graduating in 1993 with my MD. Then educationally went to residency training at Emory University School of Medicine in Atlanta, studying general psychiatry, finishing that in 2001, and then did a one-year fellowship in forensic psychiatry, also at Emory University School of Medicine, and completed that June 30th, 2002.
Judge, I'll stipulate to his.
Okay, very good. Go ahead.
So and I appreciate that, but I want to then be specific about your experience with criminal justice issues.
Yes.
Do you or have you taught in that area?
I have and I do. I have a adjunct appointment at the Emory University School of Medicine with the Department of Psychiatry. So I teach the forensic psychiatry fellows. That's on a volunteer basis, Your Honor. I also have an adjunct appointment. I'm an adjunct professor at Emory University School of Law, and I've taught a class called Mental Health Issues in the Criminal Justice System as the lead teacher there, which is an L2, L3 class, 2-hour class elective. I've done that since 2023. Prior to 2023, I taught certain sections of that class, that is criminal responsibility or competency to stand trial, but I took over the responsibilities in 2023 and continue to do presentations both for in the criminal arena, both for prosecution groups and criminal defense attorneys, presented to the Prosecuting Attorney Council of the state of Georgia numerous times. It's pronounced GACTO, if I've got it right. Mr. Findling may correct me if I've got it incorrect, which is the Georgia Association of Criminal Defense Lawyers. Presented to them various public defender groups and some judge groups at different times at the State Bar of Georgia.
And do you hold any particular certifications?
I do. I have a board certification in general psychiatry from the American Board of Psychiatry and Neurology. I also have a added qualification to board certification in forensic psychiatry, also from the American Board of Psychiatry and Neurology. And I've held those since 2001 and 2002, respectively.
And do you volunteer your time for sort of the betterment of the study of psychiatry in the criminal justice system?
I do, certainly within the realm of general medicine, the regulation of medicine. I was honored to be appointed by the governor of the state of Georgia in 2019 to the Georgia Composite Medical Board, which regulates licenses and provides some education for license holders, physicians, and physician assistants in the state of Georgia. I chaired the medical board in 2022, 2023, and got reappointed to the medical board, which is a 4-year appointment. So I'm coming up on my 8 years there. And also continue to stay involved in the community through my faith organization as well as the broader community and doing educational offerings on mental health in general.
Have you testified as an expert on psychiatric issues in the criminal justice system?
I have. Overall, I've testified over 290 times, mostly in the state of Georgia, Your Honor, but also in military court-martials as far as away as Germany and around the United States, and federal jurisdictions as far U.S. District Court as far away as Oregon, sometimes on civil matters in the criminal arena. The majority of the testimony is on competency to stand trial with kind of this number 2 spot being criminal responsibility, and then the third being issues related to sometimes issues of bond or as an educational witness related to mental health.
And with regards to your testifying, do you testify just for defense lawyers?
No, because I get asked this question in civil cases as well as criminal matters. Over the last 5 years, the average is about 40% for the prosecution or about 60% for the defense. So it's a fairly even split. If you really go back to 25 years, I've been testifying, it's pretty close to 50-50 in criminal matters.
And have you testified in the past as an expert on the psychological effects of conditions of confinement?
I have.
So are you familiar with the literature, the studies, all of that have been done?
Yes. So both within correctional literature as well as within the psychiatric literature, the effects of confinement on mental health, particularly some of that literature goes all the way back to the 19th century, which may be surprising to the court, but there were notations made by Alexis de Tocqueville back in the early part of the 19th century on solitary confinement in New York at that time as he was visiting prisons in New York, and talked about the difficulty of solitary confinement and sort of isolation on the human condition. That literature has been updated since that period of time, and there are numerous articles in the medical literature and the psychiatric, and in particular forensic psychiatry on the impact of solitary confinement and really isolation. So kind of two different issues, one being that 23-hour lockdown with 1 hour out, being quite isolating and sensory deprivation that goes along with that. And then the other component is that's one that I've heard a little bit about in here, not necessarily 23 hours of lockdown, but certainly less social contact than we as humans expect on a regular basis, and the mental health impacts there, which would include depression, anxiety. It goes all the way up towards individuals having suicidal ideation from that social isolation, from the deprivation that can occur. Some individuals become psychotic, and at times it has become such an issue that the literature supports that the United Nations calls it the Nelson Mandela rule over isolation that was passed in 2015. And then the American Psychiatric Association has come out with a position statement stating that individuals should not be in solitary confinement or social isolation for periods of over 15 consecutive days. Juveniles should not be subjected to that at really any point in time, according to that position statement. And again, it's just a position statement, but it is what the science supports.
And when we talk about the science, it's based on lots of research?
It is. So a lot of the research is based on the research that I'm commenting on is research that's in peer-reviewed literature, generally accepted among the peers. Some of it has been poked at. There's obviously research on both sides of the equation. One of the things I've learned is in teaching at law school is attorneys seem to like bright lines and well definition. Maybe they don't. Medicine really hates bright lines. There's really nothing in medicine that seems to be just fixed because there are 8 billion different copies of DNA. So even within the literature, there is some disagreement on the impact of these kind of conditions on individuals, but the general consensus in the literature supports the negative implications from a mental health standpoint, at least, not from a necessarily safety standpoint or what BSO has to deal with from that standpoint, but solely from a mental health standpoint, the impact that it's generally accepted that it has a negative impact.
And just with regards to that, in terms of the research and the empirical studies, obviously you've heard the testimony as to whether BSO was appropriate in imposing limitations. Is there anything with regards to the mental health impacts that is somehow weighed with the inmate's behavior?
Yeah, I mean, some of what I've heard, I mean, the behavior, I can understand, and again, not commenting on what BSO has to do to try to maintain order, get discipline, structure within a facility. From a mental health standpoint, when an individual is placed in isolation or has some sensory deprivation, that is, there are restrictions around their communication. We at our core as humans are social creatures. We don't like to not have contact with other humans. Even I mean, I'm an introvert, but even the most extreme introvert still likes to have some human contact.
I just love that. I was just about to say this and stop this. That even the people who say, I hate being around people who really feel that they're introverts. Listen, we are humans. It is natural for us to crave some type of relationship, right? Whether this is a relationship with multiple people or just a relationship with a few people. At the end of the day, we're humans, and it's just natural. So for them to take this away, imagine what it does to the human psyche for you to literally be going against where we are, it's embedded in our DNA. Every human is embedded in us.
To have very limits on contact. Humans will go to lengths to try to have human contact, even if that's a violation of the rules. That's our innate desire to do so, be that written communication, oral communication, or visual communication with other human beings. That's part of who we are.
Have we seen that in other situations that are more extreme and more on the line than a potential disciplinary report?
Yes, there's one in particular that comes to mind. I know it's mentioned in some of the psychiatric literature. The late John McCain, who was a prisoner of war in Hanoi, in my understanding, regularly those inmates passed notes to each other. I don't know whether they called them pints, but they had a form of communication, either by banging on the wall, having a sense of communication so that they had other human contact. In that circumstance, those prisoners of war were doing that with the risk of torture if they were caught. They still made that communication because they needed that human contact. That was part of survival for those individuals.
So when we talk about prolonged periods of isolation, what is the expected behavior? Behavioral disorder.
Again, given that there are 8 billion different copies of DNA on this planet right now, there's a lot of breadth. Some individuals would obviously comply, but again, human nature and our innate desire for that human contact would be that people may come up with ways to violate those rules in order to have contact with other humans, because we want that.
And having sat through the testimony about first, let me talk to you about Mr. Demons' confinement conditions. Do you have an opinion as a psychiatrist on the impact of his isolation?
So far, what I've heard is that there have been a couple of different housing situations, one of which could include what is often referred to as the segregation, the 23 hours lockdown with 1 hour out at different times. Sounds like that may not be the situation now, but what I have heard is the limit in the human contact to really one other officer for much of the day, although there can be contact with mental health staff, which I would hope at a minimum would be available to him if he needs that. But that still is extremely limited contact and can have a negative impact on an individual with that level of restriction on their ability to feel fulfilled, have ability to concentrate, not have excessive anxiety, not have depressive mood.
So the fact that, as you heard from Major Corbett, Mr. Demons can walk around a lot. He has a lot of space, and he has a TV he can listen to and change the channels when he wants to. Is that kind of sufficient to make up for this?
I love her.
Human need for socialization?
In my opinion, under that scenario, is not. I mean, again, I go back to and I'm not trying to date myself or the court in any way. I mean, it was a Tom Hanks movie that talked, where he's trapped on an island, and it was a very isolating situation where in essence, he started, I mean, again, I haven't seen the movie in a long time. He was talking to coconuts. I mean, there were hallucinations. It was very depriving. Again, he had a whole island to himself. Lots of us may think, this is great. I've got all this space. This is all mine. And perhaps at first that's positive, but becomes a negative because of that isolation and the lack of contact with other human beings.
And that is supported by the studies, the research, the peer-reviewed articles that have been published.
It is. I mean, it really goes to the isolation piece.
I'm sorry, but is there anyone on the live who had to read Robinson Crusoe in like 9th grade? Because I remember reading Robinson Crusoe. So when Castaway came out, you know, I don't know if it's based off of that, but that's what it reminded me of. But yes, that man was on that island for years. Seems fun at first, but then you're there by yourself. That man was hallucinating. It was all types of foolishness. So it's very similar.
You have not spoken to Mr. Demons, right?
I have not.
Okay. So this is not an evaluation of Mr. Demons.
That is correct. It is not.
This is an evaluation testimony regarding simply the conditions for another human being.
Yes, I view it as the state of the science and the education as it is within psychiatry currently, hoping to help that ponder.
And sir, you have testified around the country in various settings. Have you ever seen a detainee that was in such complete isolation for so long as what you've heard here today?
I don't know that I've seen that length of time. I mean, again, from an occupational standpoint, I was one of 2 psychiatrists at the Atlanta City Detention Center, which at the time for a decade, which had plus or minus about 1,000 detainees, pretrial detainees at the time. I provided the psychiatric services. There were individuals that were segregated or isolated for various reasons at different times. It was always something I as a psychiatrist would take very seriously. I don't know that I've heard of somebody with nearly 7 years of that level of isolation.
Does age make a difference on the impact of isolation on a person in custody?
It can. Again, what the scientific literature, which I think I briefly mentioned to the court, was that part of the reason the American Psychiatric Association really came out with a position statement on restricting this for juveniles is the adolescent brain is not fully formed and it has a larger impact. So when we talk about adolescent brain, again, this gets back to that bright line. 18 is not the end of adolescence, according to the science. Adolescence extends upwards of 24, 25, 26. And the science supports that the impact of that social isolation on a younger brain can be compounded. That is, it is potentially more damaging than those of us that are older adults like myself.
And speaking about sort of the younger brain, are there some expected shortcomings for a young person in custody?
Yes, in particular, there's a large body of scientific research and there's a forensic psychiatry article that summarizes a lot of that written by Peter Ash that talks about adolescent culpability. The idea and the concept is, and I think jurisprudence says, hey, we don't hold children to the same standard that we do adults. And the question is, again, should this be some arbitrary bright line at 17 or 18? So what the science shows is that adolescents are more impulsive because of a lack of a fully formed prefrontal cortex. You would have thought that science would have figured this out way before the car rental companies. However, they figured it out way before science did, and that they would not rent cars, probably still do not rent cars to individuals under the age of 25. There's a good reason for that. They're higher risk. Youth are higher risk. They don't have the ability to think through long-term consequences as well as those of us with hopefully having youthful fully formed prefrontal cortex, which controls executive functioning, planning, long-term consequences. It's why probably in lots of criminal matters, the court sees more youth offenders than older adult offenders.
And so when, you heard about Mr. Demons having some issues when he was first in custody at age 19 with getting in a fight with other detainees, is that surprising?
It is not surprising to me.
Being disrespectful to staff?
That is not surprising to me. I mean, my understanding is he's just now 26, just now reaching the age around which that prefrontal cortex is fully formed and may take into account long-term consequences on a much better basis at this juncture.
And what we did hear is that, and see in the records, the majority of the violation of rules appears to be related to sociability. Does that surprise you?
No, and that's how I heard it. I mean, it was communication. So again, if isolated from communication, and that's part of our innate nature, trying to engage other humans in communication is, from a psychiatric mental health standpoint, is to be expected if that is severely restricted.
So our trial is scheduled in January of 27, so 8 months away. There may be some thought about what's another 8 months, given we've already passed the 7-year mark. In your opinion, does that matter?
It does. It matters only from the standpoint that it's cumulative. That is, it's not like somebody becomes accustomed to the isolation. They may accept it. There may be learned helplessness, which is I don't know how much psychology the court took in undergraduate, right? It's you put a rodent in a cage and have them press a button and they get food at first, but then they get shocked. If they continue to get shocked at some point in time, even if they don't have to press the bar to get shocked, they just cower in the corner and accept the shock. And that's a lot of B.F. Skinner's research on learned helplessness. So some individuals there's learned helplessness. It doesn't mean that the damage does not continue and it's cumulative.
And when you say cumulative, so 8 months, what is what does that mean, cumulative, when it's preceded by 6 years?
Yeah, I mean, again, it goes back to, I had heard of somebody being that isolated for that length of time. It's where the general consensus among mental health practitioners within a correctional setting that there's a national organization that looks at correctional health. They have their guidelines says no more than 15 consecutive days in isolation segregation. A prohibition of individuals with a known mental health condition being put in isolation or segregation. So even an additional 15 days could be, from a psychiatric standpoint, could be damaging.
And what about the fact of an impending trial? Does the long-term isolation, the cumulative effect, play into an impending trial?
Again, it could. I think when I think of a pending trial and doing competency stand trial evaluations fairly frequently, trial for most, again, I can still get anxious coming into court. This is not my office, right? A defendant coming into court, it's not their venue, it's not their office. They usually have anxiety just at baseline. It doesn't mean they're going to be incompetent. Most are not incompetent. Then add to it a potential long-term incarceration as an outcome, add to it a potential capital offense as an outcome. Anxiety is going to go up. When anxiety goes up, little bits of anxiety are great. If you didn't have any anxiety, I don't know, you would have passed the bar. I know I would not have passed the USMLE, the licensure examinations. Got to worry a little bit. If you worry too much, you don't do well. And the same thing is true with individuals as defendants. A little bit of anxiety, probably good. They'll stay focused. They might stay quiet. They might just pass types or notes to their counsel. But too much anxiety, and they're not going to be able to effectively assist their counsel.
And so we kind of started some of this with the idea that the conditions that you've heard described can actually impact anxiety.
Yes, the literature is very clear on causing, not just somebody who has anxiety beforehand, but actually cause it for anxiety.
And so when we combine that with sort of the stress of a trial on, you can't get more serious than a capital case, right? What, in your opinion, are potential issues?
I mean, again, the potential issues is the cumulative effect of that. That is that it degrades, and again, now to the point of, I haven't examined the defendant, so I'm not talking about his competency, anybody's ability to really effectively and competently assist their counsel. The more anxiety they've got, and if you've got two things that are causing anxiety, they're going to compound each other. They're going to make it worse.
So the fact of 8 months before trial, given he's already been in these types of conditions for 6 years, in your opinion, is that a serious concern?
Could be from again, solely from a psychiatric standpoint, mental health, it would be optimal for an individual to be able to assist their counsel under those conditions, under different conditions than what I have heard are occurring currently.
That's all I have. Thank you.
Thank you.
David, I wait for,
She was just here.
She ran to another courtroom, she'll get back, okay, to start.
Okay, so let me go back on the record, this is State versus Jamell Demons, 19-1872 CS10A. I continue to have Ms. Bucklew, Mr. Griffiths present for the state. I continue to have Ms. Howard, Ms. Abden, Mr. Findling present, Mr. Demons, who likewise is present. When we press pause for lunch break, we're in the middle of the defense presentation. We're gonna pick it up right at that point. Defense, you may call your.
Thank you. Your Honor, at this time we call our fifth and final witness, Victor Delgado.
Sir, if I can have you come all the way up here to the witness stand, please. Once you reach it, but before you have a seat, you can just stop and look at it. Raise your hand. Swear to tell the truth, all the truth, nothing but the truth. Please be seated. So once you're seated, you can scoot that chair forward. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
Victor Delgado, VICTOR DELGADO.
G-A-D-O.
DO.
You may inquire.
Thank you. Mr. Delgado, you've never testified before, have you? Okay, I know you're a little nervous.
Yeah.
Okay. Mr. Delgado, can you explain to His Honor what business you are in?
Yes. I'm a CEO of YNW Civil Protection. It's a company based in Miami, Florida. Also, we provide services worldwide. Our team is built by military and law enforcement.
You're gonna have to slow down a little bit. Yeah, you want me to, and raise the mic a little bit so we can hear you better. There you go, sir.
Better?
Got it.
Okay, sorry. All right. I will say, I'm the CEO of VND Executive Protection. I'm the CEO of VND Executive Protection.
VND.
Executive Protection. And can you describe what V&D Executive Protection does?
Yes, we provide executive protection services, residential security, tool security, armed guards, transportation, political trucks. Like I say, our team is built by military and law enforcement. My director of operation is a former Marine sniper, and my other operation guy is Navy civilian and also law enforcement.
Okay.
Myself, I used to be an instructor for a few police departments for Brazilian Jiu-Jitsu, and self-defense tactics.
And are you a former MMA fighter
Yes.
yourself,
Yes, sir.
professional?
Yes, sir.
And so in summary, you have executive protection. And can you just quickly describe for His Honor the type of people that you provide protection for?
Corporate clients, athletes, celebrities, entertainers, and pretty much two royal families, one in Miami, which I can't say the names, and the other one from Dubai when they come out here.
Okay. Now, without giving the address, did you, at my request and the request of the defense, do an inspection on a home in Broward County?
Yes, sir, I did.
Okay. And you understand that we represent Mr. Demons, Jamell Demons, correct?
Yes, sir.
Okay. And Jamell Demons. And do you know who he is?
No, sir.
When I contacted you, do you have any idea who he is?
No, sir.
And you've since found out through your research that Mr. Demons is a musician, correct?
Yes, sir.
And you've learned that he's been incarcerated for 7 years, correct?
Yes, sir.
Now, before we talk specifics about the work that you've done, that you potentially could do, regardless of whether it's a celebrity or someone was a celebrity 7 years ago, or it's a corporate executive, do you place who that person is professionally above doing the right thing, and that is complying with the laws of the state of Florida and the United States?
Clients are client, and I make sure myself and my team nobody know regulations or law. Our job is protected with protect our client, but sometimes we're not allowed to break the law.
Okay. So in other words, you create no friendly relationship with the client.
My job is to work from plan to lead, and this is it.
Now, you did a full inspection of a certain home in Broward County, correct?
Yes, sir.
Okay. Without saying the address of the home, can you give like the approximate size of the home and a
Yes.
physical description? You don't have to be too detailed, for His Honor.
Yes, it's a gated community with 24/7 security. They got 4 entrances and 4 exits. Each one they got on armed security guards, and then they got police on going there pretty much every hour. Because the police station is literally like 2 blocks away from there.
And Mr. Delgado, I've explained to you before that we're asking His Honor to give our client pretrial release before a trial coming up in January. You understand that, correct?
Yes, sir.
And if Mr. Demons is released on bond and there are conditions, for example, that your company's responsibility is, let's say, for him to go to court to make sure that you protect the community
100%.
and him, will you follow those instructions?
Yes, sir.
If there is a court order that says if he does anything that is deemed to be inconsistent with this order, you will report to any authority that His Honor would require, whether it be the court, probation, even Madam Prosecutor. Would you do as the court instructed?
Yes, sir. And myself and my team, we basically care for our reputation. So our team and ourselves, my team and myself, we care about our reputation. So we don't, like I said, we track clients, like regular clients. We don't give no privilege out here. And then we follow rules. The fact my team is law enforcement and we follow any order. And I'll be the first person who reported it. I have to do it.
And if, because we're offering up and if His Honor, because we're offering up your professional security services that are used for corporate executives as well as entertainers and athletes, if His Honor structures a bond order that requires even more responsibility for protecting the community and even Mr. Demons than just to and from court, whatever that would be, would you honor the court's request as stated forth in an order?
Yes, sir.
And would you personally study that order to make sure that there was full compliance?
Yes, sir.
Okay. And if the court, for example, ordered, at least when Mr. Demons was in your presence, something like no social media, would you do everything in your power through your assistants to make sure that he complied by studying the household, studying his possessions, etc., to make sure that he complied strictly with everything that the court required.
Yes, sir. I say we make sure nobody,
And would you, even though that Mr. Demons and the defense would bear the cost, would your obligation, even though we'd be paying, would your obligation be to us as the payor or the court?
court.
Okay. And I believe, without getting specific, very recently you told the defense that you basically broke a contract with a very famous person because they wanted you, don't be too specific, to do something that you believed was not proper. Is that correct?
Yes, sir.
And you, by doing so, you passed up on making a decent amount of money
Yeah.
because you wanted to comply with the laws of the state of Georgia and the United States, correct?
Yes, sir.
That's all, Your Honor.
Cross-examination.
1 second, Your Honor.
I'm sorry, Your Honor. Can I just follow up real quick? I apologize. We heard through previous testimony that it's a single-family house, correct?
Yes, sir.
And you understand that inside that house, there are facilities that he could work. In other words, there's an actual music studio in there. Is that correct?
Yes.
And you corroborated that yourself, correct?
I got a studio, 3 rooms, and 3 bathrooms.
Okay. And I'm sorry, I neglected, without getting too specific, to give away the location of the house. You also said that if you're retained, you would require the home to have certain surveillance cameras installed
Yes, sir.
because it would help you get your job done to better keep the home and the community secure, correct?
Yes, sir.
And you furnish those to us so that we can accomplish those goals in order for you to accept a written contract by us on behalf of Mr. Demons, correct?
I will allow you all the logistics and all the inspection to you, so you can see everything.
Okay. And so those were done because you want complete visibility at all times, so you can make sure when you're involved that the court's order is being complied with, correct?
Yes, because I don't want to put myself in a situation right now.
That's all. Thank you.
Say cross-examination.
Yes, Your Honor. Good afternoon, Mr. Delgado. How much would you be charging the defendant for 24/7 surveillance?
Can I say it?
Yes.
I was thinking at the time, the price normally we charge a company is about $1,600 a day for 24/7.
You said 6,800
Yes, ma'am.
a day.
Yeah, for 24/7.
What the hell?
Okay. And were you hired, if the defendant is released, to have 24/7
Yes,
surveillance?
that was the condition I thought of.
Okay. And so $6,800 a day until he's potentially released if he's found not guilty, correct?
No, it's as soon as he released or he retained me, I'll be charged those things.
Okay, so you haven't officially been retained yet.
I put the official retained for today, and if we go to January, he gets there with the January.
Okay. All right. So with 24/7 surveillance, does that mean that someone such as yourself or someone on your team would be in the bedroom with him while he's sleeping?
We don't have cameras. Like I said, we inspect the house. We don't have like in and out of the house. Also, the community is a gated community. So I present myself with the association out there, tell them I got a potential client coming up. If he does, we want to be outside, inside the house. So just to avoid situations, people thinking was going to see a car outside with the lights or a car outside armored. So I was thinking to provide between 1 and 2 cars a day.
Okay, for 24 hours a day.
Yes, so pretty much we keep on the alone.
And so they won't always be side by side with the defendant, correct?
Yes, because the house is pretty much, like I said, it's not that big. It's 3 rooms plus the studio. So pretty much the house got access for the board. You looking in the house, outside, around the pool area, so you can see what is going on, okay, everything, because the house full of glasses. It's for glass, so you can see, trust me, what is going on. Already, specifically, I went to his room to see how many entries I actually had. He only got 1 entry. Go to the pool. So I told my guard, make sure with everything there, we're gonna put civilian cameras outside the pool. Make sure it's proven in case something happened. we can follow the court order.
And can you give me a list of every single person that would have access to this camera system?
Myself, I'm a two-day operations.
Okay, would the defendant have access to it?
No,
Would his attorneys have access to it?
I was thinking, no, in the moment, because he didn't ask me for it, but I was thinking it's myself. I'm a two-day operation. I have few residentials, and only we allowed to see myself on a two-day operation. Yes, for safety purposes, in case something happened, that will help me out because I approve of videos.
And are the cameras Wi-Fi based?
Yes, high definition, night vision, sensor, everything. I already provided information to my camera guy, and they already went to the house inspector. As soon as he gave me that order, they we started.
And will someone be watching these cameras 24/7 as well?
Yes, that guard was there, and myself. So pretty much whatever guard I put in the house, we access to monitor the cameras, myself, and my two-day operations.
And where are these cameras going to be set up within the home?
One in the front, two on both sides, two in the back, one before the pool, close to the room. So it's pretty much going to be a full high definition camera. So when normally the guy had to use, when he connect the camera to the house, he put it that way you can see the whole house super clear,
How about the bedroom?
everything. Because the thing that bedroom's inside, the only way I can see the bedroom is when they close it, when the curtains. But when the curtains open, if we feel something's weird, we already told him, we go inside to figure out what's going on.
So that's what I'm asking. You're not going to be placing cameras within the bedrooms themselves?
I was thinking, no, at least that court requirement, because I don't want to see somebody privacy, you know, in the bathroom, he can be himself, sleeping naked, who knows? So it's a private area, but if you guys require, we do it. There's no problem with that. Like I said, I'm here to follow whatever court is sending.
No further questions. Thank you.
Based on that, you redirect?
They don't have cameras in their cells, do they? I don't think so.
While he's doing that, Ed, you ready? You call your answer?
Your Honor, at this time, we're ready to go into argument on.
No additional evidence, witnesses, or testimony on behalf of the defendant. Okay, sponsor, state, any additional evidence, witnesses, or testimony from the state?
No, Your Honor.
Just your argument?
Yes.
Okay. All right, so defense, whenever you're ready, your argument, both parts, number one, my determination, if I would still find proof evidence presumption great or not. Number two, even if I did, and you're asking me to exercise discretion, tell me exactly what you want me to do. Whenever you're ready, you may proceed.
So, Your Honor, beginning with proof evident presumption great. I know that the state is relying on the transcript which Your Honor's had an opportunity to review. There was a hearing approximately 51 weeks ago. There have been change of circumstances, which I'll outline for the court, we believe, over the course of the last, let's say, approximately 1 year. And I would say it's somewhat ironic. We've heard testimony about our client going into custody in 2019 at 19 years old. The irony is that tomorrow, this young man turns 27 years old, and he's been in custody since 19 without ever having been found guilty of a single offense, with one indictment having already been voluntarily non-processed by the state. But we find ourselves here, and I want to address proof evident presumption great. And the first thing I want to talk about is one of the change of circumstances is that Judge Murphy's granting of the motion to suppress has been affirmed by the Court of Appeals. And it's worth noting that not only was it affirmed, but no good faith exception even applied. And the gist of that affirmative finding and the underlying motion to suppress goes to the credibility of Detective Mirhadi. And we spent a lot of time studying this trial and studying the transcripts. And of course, we've had the unique opportunity to see YouTubes of a trial. That's a rarity. And it's fair to say that two things take place. One, as was discussed earlier today, so much of this case was about a hearsay statement by Cortland Henry. But this case was navigated by the field general, that being Detective Mirhadi. Detective Mirhadi, who was the subject of the affidavit, was found to, his credibility was called into question in the granting of the motion to suppress and ultimately the Court of Appeals position. And so to us, that's really important because it actually, we know that the court, we're aware of the court having found proof evident presumption great a year ago, but in light of his credibility into being called into question, we are strongly arguing that the court think about the chiseling away of his credibility, the chiseling away of his believability, not to his investigation itself, but just to the issue of credibility, because as the court is well aware, credibility and even impeachment are what generate, through instructions to a jury, et cetera, what it generate reasonable doubt. But for your purposes, what chisel away at proof evident presumption great. And stepping in and looking at this, I think it's essential, and we think it's essential, that the court look again at the issue that involved the July 27th, 2023 interview of Michelle Boutros regarding a statement that took place October 12th, 2022, understanding that the defense team that tried that case, the transcript as reflected that Your Honor reviewed, did not have the benefit of that knowledge. We have studied the examination of particularly Mr. Adelstein, who spent what appeared to be hours and hours cross-examining Detective Mirhadi without the benefit of understanding and knowing and having been given that information. And we know how that impacted the state attorney's office, but what happened on October 12th, 2022. And of course, as the court is well aware, that involves Assistant State Attorney Michelle Boutros. And it doesn't escape me that she was with the Public Integrity Unit at the time. Revisiting that for a second, as the court knows, at the state attorney's office in this building, there was a service of an interview and a search warrant on Jamie King. And at that time, because he was outside of his jurisdiction from the city of Miramar, he needed to have somebody from Broward County Sheriff's Department there. He did not. And so what transpires, according to, and I just want to say for a second, as a career criminal defense attorney, with great respect to people that do crimes, major crimes, prosecutors that specialize in homicide, prosecutors that specialize in crimes against women and children, as a defense attorney, our most difficult cases are dealing with the public integrity unit prosecutors. They are what we call sometimes the truth prosecutors, right? They protect the thin blue line between corrupt law enforcement, overly violent law enforcement, and the community. They're the ones that handle corruption, political corruption. They protect the community from corrupt public officials and public employees. Personally, I have been dealing with public integrity unit prosecutors I have incredible respect for, from my representation of law enforcement officers to elected public officials at the highest level. And they consider themselves to be the integrity, the truth prosecutors. So the fact that this involved somebody from a public integrity unit speaks very strongly to the defense on behalf of Mr. Demons. And so to have Ms. Boutros say that she was in a room with the lead detective in this case, Detective Mirhadi, and the defense tried this case, and Mr. Adelstein do his cross-examinations and not know that she made a statement that in that meeting in 2022, Detective Mirhadi said to a deputy from Broward County Sheriff's Department, "You need to say you were here when I served the search warrant." For her to say, "I immediately reported this to my supervisor," to her to say, I won't work with Mirhadi anymore. I would not have anything to do with investigating with him. For somebody from the state's attorney's office, and I'll give you that transcript if Your Honor doesn't have it.
And Judge, if I may, I'm just going to object at this point. None of this is
No.
evidence, so I'm
No.
confused on how we're now bringing this up in argument.
It's just his argument. He's talking about the reason that the state attorney tried to do this trial.
And for her to say, you don't have, Thank you, Your Honor. You don't ask another law enforcement officer to lie for you as a joke, and I wouldn't work with him anymore. And the case was given back to the then trial attorney, Christine Bradley. Why is that important? Well, it's important because in the transcript, Your Honor, there are numerous times when Your Honor is reading that transcript and taking into consideration whether or not proof is evident and presumption is great, you have to think respectfully about what was lacking. At the crescendo of Mr. Adelstein's lengthy cross-examination of Detective Mirhadi on July 17th in the transcript, on page 95, line 3, he talks about lying could result, talking about witnesses in his cross-examination, lying could result in somebody being charged with a crime. Page 95, line 17, not being truthful could result in being arrested, talking about accessory after the fact. But again, Mirhadi addressing the issue of lying. All this without Mr. Adelstein having the ability to impeach and thoroughly and siftingly cross-examine Mirhadi about the fact that he was requesting another law enforcement officer to lie. Armed with that ability to cross-examine in front of a jury that was unable to even reach a verdict in this case is something that the court should take into consideration as we chisel away by the original finding. He says this similar statement again, lying could result in being charged at page 96, line 17, page 98, line 8, lying could result in their arrest. And so the credibility of Detective Mirhadi, this is the lead detective. This is a case, again, as the court noted, that is basically relying on a hearsay statement by someone whose case was ultimately dismissed with a jury that couldn't reach a verdict, and a detective who is literally the summary witness. He is bringing it home, not just summary witness interviewing records, but bringing home all types of issues regarding his opinion and marshaling evidence and rendering opinion after opinion. On that same date of July 17, 2023, in one of the most important parts of the cross-examination by Mr. Adelstein of Detective Mirhadi, he hits him with a crucial issue, which is you did not seek a search warrant on or about October 26th or in the weeks afterwards regarding the one place that you should have sought a search warrant, the most obvious place possible, which is the residence of all 8 people that were at the studio the night this happened, including Cortland Henry, including Mr. Demons, including the 2 decedents, and then 4 other witnesses. Mr. Adelstein, as he should have, cross-examined the detective. Tell me about your search warrant. I didn't get one because I didn't have a nexus. I made sure I called Ms. Howard to find out whether Florida was different than the rest of the United States, where we look at probable cause. When a detective talks to a prosecutor and talks about probable cause, the bottom line is Detective Mirhadi dropped the ball. He went after the shiny objects, which resulted in this massive suppression of phones and Twitter accounts and all these little shiny things, but didn't look to the one place where your decedents and your defendants were residing. And his answer was, I didn't have nexus. Well, if he had been armed with the fact that this detective did the most egregious thing that a detective can do, the most egregious thing, and that is request that another officer lie and get called out by a prosecutor. If he had been armed with that information, if the defense had had the ability to even not only impeach, but to call Ms. Boudreaux, because they could have done that, it could have been a very, very different transcript. And I think it's important that the court take that into consideration. The state attorney, Broward County State Attorney, makes their decision on how to move forward. They made a decision after 2022 to go with a detective as a lead detective in a case that requested another officer to lie and cast aside the opinion and the philosophical and ethical beliefs of one of their public integrity prosecutors. That's something they have to live with. And obviously there's been a change of guard because of that type of behavior. But it is something that the defense was denied. So when you read that transcript, I saw before in the previous hearing before we were involved, that your Honor said, and I appreciate it, that I believe you said, I could do a Franks versus Delaware analysis on this. I think that was a quote from what I've read. And I think that's a great way to do that. And so we would ask the court, when you re-review, whatever you re-review, to take these things into consideration. And there's just numerous other examples of where Detective Mirhadi could have been cross-examined and impeached based on the fact that he has requested somebody to lie. That goes to his veracity. More importantly, that goes to his credibility, which generates reasonable doubt. When Mr. Adelstein cross-examined him, going through at the tail end of his, in the beginning part of his cross, he went through all the places that he passed and asked if he looked at security videos. And then he said, I didn't do this one and that one. And then on redirect, he said, well, in a question by Ms. Bradley, most of them, like CVS and Walmart, focus on what's going on inside a store. I will tell you something. Your premises liability lawyers and the limited work I've done, that is just an untrue statement. That's just an untrue statement, and Detective Mirhadi, I'm sure, knows better than that. That stores are concerned about their parking lot security and cameras are facing out all the time. But again, Mr. Adelstein didn't have the fact that Detective Mirhadi was somebody that seeks not a citizen, but a fellow officer to lie. And I've defended officers, probably more than most, on violation of oath cases, and they're pretty tough to defend. Your Honor, some other issues to take into consideration, and that is what is different between now and then from your last time you reviewed this 51 weeks ago, is that Cortland Henry, who was charged as a co-defendant in this case and charged with murder in the first degree with the use of a firearm in counts 1 and 2. Cortland Henry, who the state in that first transcript believed was lying from the first trial, who the state went out of their way to show that he had gunshot residue, he had GSR on his hand. The state went out of their way to show that he had DNA on his clothing, that the state dismissed those murder charges. We don't know. All we know what's in that transcript. That transcript, the court made some observations at the beginning of the day. We don't know from what his statement is. All we know is what he gave. But what we do know is that at that time, he was charged with murder. For whatever reason, given all this, the state's assessment of this case is that his case, without any cooperation, was worthy of a dismissal. And that should speak volumes to the court when the court is assessing proof evident presumption grade. Because there's really nothing in the record that the court could look at. Nothing evidentiary in the volumes that you've looked at to distinguish these two individuals, Mr. Henry or Mr. Demons. And so that's yet another thing to take into consideration. To the extent that the court has looked at the tampering case a year ago, because a year ago that case existed, to the extent that that was something that the court was contemplative about. Your Honor knows that we got in this case, I believe, last August, and Ms. Howitt and I, from the very, very beginning, were absolutely committed to trying that case. There was no attempt for us to continue the case. As the court noted, we came into the case, filed a series of motions. Quite frankly, from a defense perspective, there wasn't a lot done on the case. We really weren't clear which of the attorneys was actually in the case and who were not in the case. But we came in and not wanting to continue anything, trying to handle things with efficiency and promptness, filed our motions, ready to go. We laughed yesterday as we prepped for today about we have text messages and phone calls on Christmas Eve. We were in communication through the holidays. Your Honor was kind enough to have 250 jurors ready. I believe you said you had 250 backup. The day before that trial, the case was dismissed with what we thought was without explanation. And then, of course, as we noted in our motion for bond in our footnote 1 or 2, the state issued a statement about not wanting to wait for a ruling by the court. That's just unacceptable. And the bottom line is that the state didn't give Mr. Demons the ability to get his not guilty verdict. Because I'll say right now, that would have been a 30-minute not guilty verdict. It would have taken 25 minutes to choose a foreperson and 5 minutes to deliberate, and he's found not guilty in that case. So he was denied that opportunity to get his not guilty. So when we look at the first issue of proof evident, presumption great, and I know these are issues that the court is very aware of. And it's interesting, and Your Honor, I think pro hoc vici is not a right, but it's a privilege, so I appreciate that privilege, and I'm trying to do everything I can to understand, because things are different when you travel around, but some things are not different. So here's what's not different when we use this incredibly high standard in the state of Florida, which is beyond guilt or reasonable doubt, and that is that this is a case that a jury was not able to render a verdict. One, this is a case with no DNA implicating Mr. Demons. Two, this is a case with no fingerprints implicating Mr. Demons. Three, this is a case with no surveillance showing that he had anything to do with being in a vehicle or, more importantly, shooting anybody. Four, this is a case with no eyewitnesses whatsoever. Five, this is a case where we have a detective, the lead detective that ties the bow and brings it home at the end, that is asking another officer to lie. Your Honor, I'm not one of those lawyers that says at night, God, what a crappy profession. I hate it. I love being a lawyer. My history is full. That's how Ms. Howard and I are friends. We're not friends from trying cases. We never tried a case together. We have both been committed our whole careers to bar associations and teaching young lawyers. That's the foundation of our friendship. So we're both lawyers that are honored to be lawyers and respect the other side. Respect, you'll never hear me condemning prosecutors, and I always will jump at the opportunity to represent somebody in blue because our society needs them. But here's what we don't need. We don't need a lead detective pinned up against a public integrity prosecutor and right in front of her trying to get another officer to lie. That casts doubt on everything that Mirhadi does, everything that he touches. And I will be the first person to be shocked if he stays lead detective in this case. We've all done cases where somebody, for whatever reason, is removed from a case and a new person comes in and picks up what they did. But hey, if this case goes to trial, bring him on because he's a liar. And so then we have ultimately the motion to suppress that is affirmed by the Court of Appeals, which casts doubt again on his credibility. And so when Your Honor does the proof evident presumption great, I ask you to take all of these into consideration. And of course, what we talked about earlier and the fact that a co-defendant who, if you read the indictment, is side by side culpability wise, that case is dismissed. And I just would argue to the court that all of those just chisel away at the court's previous finding of a year ago. And so unless the court wants me to do otherwise, I'll hold off on the second part of the argument until after the state goes. Do the whole thing? Okay, thank you.
That's everything in proof evidence.
Yes, sir. Yes, sir.
And then if I exercise discretion, or if I agree with you and I find the circumstances have changed, I don't find proof evidence presumption great, exactly what you want.
Yep, I will. Thank you. Give me 1 second. So, Your Honor, in looking at your statutes and looking at your law, I ask you to exercise that discretion and set a reasonable bond. And I'm going to talk in a second about the conditions of release that can be reasonable. And I first want to talk about protecting the community from risk of physical harm. There was nothing presented in the case regarding Mr. Demons that is any way involves his threat to the community. And most important to me is when we talk about this second process is assuring the integrity of the judicial process. So I want to talk about the conditions of release that we would suggest. First, I want the court to think about the testimony that we just heard from Matthew Norman, a distinguished forensic psychiatrist that honestly, you heard he's from Georgia. I've really been more against them than with them. We've had some battles through the years, and he's an incredibly ethical and devoted to this issue and all forensic issues regarding mental health. It's worthy of note to me that the state had no cross-examination. And in like fashion, I know that last year there was, I think at the hearing, they were going to offer somebody and they served notice like the day before, and we would never do that. We served notice in plenty of time. And I'm sure that that's something the state looked into. But here's what I'm also sure of, just like there was no cross-examination. There's not a mental health expert in America that would agree that these conditions that we heard about are healthy for somebody that went into custody at 19. There's no need to cross-examine because there's nothing to ask, because it's irrefutable what we heard. It's irrefutable. It's irrefutable that 27% of Mr. Demons' life has been incarcerated without having been found guilty of a single offense. If we look at him from the time he was turned majority in the state of Florida, 18, 30.5% of his life has been incarcerated. I've looked into the cognitive state, begins, they say, at 3 years old. So his cognitive state of his existence would be 87.5% of his cognitive life has been sitting in a jail under these conditions. And so we have to come up with something over these 8 months to get him out of these set of conditions. Because, Your Honor, I've traveled. I'm just telling you, I traveled to the ruralest areas of Mississippi, the ruralest areas of Louisiana, the ruralest areas of Alabama, and have never seen the conditions that were described here. This is the single worst thing I have ever heard. And anybody that's a member of the bar, it is shocking to the legal conscience that this has taken place to somebody unconvicted. We've heard that there's been no shanks. We've heard that he's not punched anybody, been in fights with anybody, been in big events at the jail. But we wanted to see him last night. And we couldn't see him because we had to wait till everybody clears the floor so we could see little 5'6", 112-pound Jamell Demons. It's unbelievable. And so we believe that, as you heard, humans need contact. We need him to be of clear mind because the state of Florida, the Broward County State Attorney's Office, is seeking the death penalty. Now, any lawyer who knows this isn't a death case, nothing about this is a death case. That's just a bunch of crap. It's not a death case. This is, let's get a death qualified jury case. Okay? It's not a death penalty case. I've tried death penalty cases, and it's how it needs the league in death penalty cases. I feel terrible for 2 decedents in this case, but it's not a death case. It's not a death case when you're just relying on a hearsay of a guy you handed the case away to. So it's not a death case. And so we think that to get on the other side of isolation, the court should structure a bond at our suggestion. We will furnish the address to the court. We offer up security from a professional company, as we just did. We think there should be 24/7 GPS monitoring. We present to the court a continuum of how we can do the private security. It can either be to and from court, to and from whatever, whenever he leaves, whatever conditions, or the ultimate, which you heard during the cross-examination, if it's 24/7 until now before trial. That's up to the court's discretion. We will meet any obligation that is set forth in a court order. We believe that it should be a condition that, given the history of this case, we've explained to our client there'll be no social media. We're not, Your Honor, I never ask for, I just make it a part of my practice. I don't hit a number. I think that's kind of weird. That's for the court's discretion. The court comes up with the number. And if it's a number, I like to say when I'm in front of judges like yourself, I think bond is aspirational. And because it would be hypocritical of me to just come up with some number. I just think I leave that to the court's discretion. What type of bond the court wants as far as the financial obligation. Prohibition to any witnesses connected to the case. I just don't think technically I could, say that his mom's a witness. I think that it is time for him to have communication with his mother. He has not heard his mother's voice in years. Tomorrow will be, I think, the 3rd or 4th birthday where he's not had a family member say happy birthday. And so I think, we'll work with the court as far as those people that he can communicate with. But it is time for a bond to be set. If I can just confer with counsel before I conclude, that would be great. Sure. Thank you. And so, Your Honor, if I conclude by just saying the following, and that is, you may have figured out that we have studied the transcript of a year ago, and we've said, I don't know, whenever we file this, our playbook will be to try to do things, address some of the things that we think were not addressed. I know last year there were no witnesses. We wanted to make sure that we did that. And so why did we do the witnesses? We did his grandmother to show that he has ties to the community, he has ties to the Florida community. And he's just got a lot of familial support. We presented somebody from 100K Management to show that there were no problems with his company in terms of him being employed before and being employed now. In other words, he met work obligations then. The house is being provided by the company with a studio so he can do his work. He's in the rare set of circumstances where he's literally been incarcerated and music from back then continues to play, but he was employed then, he's employed now. Importantly, I do want to remind the court, his grandmother says he doesn't even have a driver's license, let alone a passport. So in terms of fleeing the jurisdiction of the court, there's nothing like that. And in terms of ties to the community, that issue is addressed. So if the court says he needs to be restricted to Broward County, then that's fine. If the court, in terms of his home, but anything else like other than come to Broward County Courthouse or whatever, if the court requires his lawyers to just come to him and work on the case, then so be it. But we think that we have hit on all of those subjects that should be of concern to the court regarding the setting of bond. And just finally, I want to say, this is not, as Dr. Norman said at the tail end of his testimony, just 8 months. 8 months is an enormous amount of time. 8 months is an enormous amount of time when, without having been convicted of a single offense, you've been spending all this time incarcerated. And I'm mindful of what we heard in terms of infractions. But these are infractions of somebody that has been in jail since 19. These are infractions of somebody that has not known really adult life. So much of his adult life has been shaped and formed in a county jail. And it is just impossible to judge somebody under that set of circumstances. Any of us that have been teens ourselves or parents, I mean, I sit and think of my kids. What would they be like from great kids from 19 to 27? I can say one thing, they're great lawyers. Two of them are lawyers, but I can tell you one thing, they would have had more infractions than him because of their desire to grow and develop. He's been denied that opportunity to grow and develop. We can't be confused by the fact that he kind of became a musical person. When all said and done, he still went in as a kid. And now he's 27. So I think the state of Florida made a bold statement when they dismissed the other case. And they're living with a case that's primarily relying on a hearsay comment of somebody that was worthy of dismissed murder cases, 2 murder cases. So that's where we are. And we'd ask that you set bond in the manner described.
Listen, before you sit down, and I'm gonna hear the state's position on both of these issues.
Yes, sir.
I'm gonna ask both of these things, 2 questions. You may not agree with me, so I don't have to, but I understand everything you're telling me about Detective Mirhadi and all the things that we have benefit of now that Judge Murphy can have for the bond hearing and available for trial. But the defendant is on video getting the call, right? No one disputes that. He's getting the call, right? With Mr. Henry, Mr. Williams, and Mr. Thomas, that's under that. Number 2, cell phone location. In the date of the homicide, you don't agree with the location of the homicide. The state is telling me the cell phone location on October 26, 2018 at the homicide. That's still that, right? And those 2 things are still. They haven't been suppressed, and it has nothing to do with leaving anyone's credibility. Those are 2 positive facts.
Can I just footnote one thing? Sure. And that is, so we are going to aggressively pursue every issue in this case. I think you could see that a little bit of different in how we approach things. And so I will say one thing, and that is there was a contrast in the testimony of a special agent from the FBI and the way the cell phone testimony was explained and offered through Detective Mirhadi. Detective Mirhadi was way more liberal in his explanation of things and was contradicted that of an FBI agent. And so I'm glad you bring that up because the state went with somebody to contradict an FBI agent with somebody that they knew and the defense didn't know was encouraging another officer to lie. I think that casts doubt on the person that marshaled in that testimony. And so we're going to dispute a lot. And when all said and done, we're not really worried about those limited facts are limited facts that are a mere percentage of everything else that transpired in the case. And that is specifically all the evidentiary issues that were lacking in the case. And I started listening for Your Honor, because those issues are what generate reasonable doubt. You're looking at a standard beyond that. And so you're looking at, and I respect your questions, and I kind of expected that, but it's the kind of issue that causes a jury not to be able to reach a verdict. And that's beyond a reasonable doubt. And that is what you just presented when you contrast it to everything they didn't have, okay, is not proof evident. It's not surpassing guilt beyond a reasonable doubt. And so that's our position. And I can't say, and I know Mr. Adelstein was trying to get there, that a lot of these other evidentiary issues that could have been established through law enforcement were not achievable, but they didn't take place. They just didn't take place. And, you know, I I served on a Department of Justice task force years ago that talked about cases like this, specifically cases like this. I'll date myself because it was around the time of Janet Reno when I was first starting this business. I worked on a task force she put together, and I remember law enforcement saying then, always reach out to organizations like the FBI, just not for cell tower, but for every evidentiary issue. If you're struggling on an evidentiary issue, reach out. That didn't happen in this case. And so this case is devoid of a lot. And that's not our client's problem. That's the problem of folks that are trying to prove a case. And so those people trying to prove that case knew a couple facts that are really important, Your Honor. If you take what you just presented to me, then what about Cortland Henry? Because Cortland Henry got in the car. That's not disputed. He puts himself in the car. And so Cortland Henry's case is gone. And so it's disingenuous for the state of Florida to say, hey, we think his case should go in the waste paper basket and give him 10 years with 6 years probation afterwards. But hold on to Mr. Demons. You know, that's a real problem.
They make decisions like that all the time.
Well,
I don't think that's what
Your Honor,
they're exercising prosecutorial discretion.
Your Honor, they may make those decisions, and my role, Ms. Howard's role, is this young man getting ready to turn 27. And so I don't get it, but they did it. And there's only one thing that the court can do while you may have doubt, and that is hold them to it. Because that is their take on the evidence they have in this case. If the one guy that they know's in the car, forget about the phones, that they know's in the car and they believe he's lying, if they take the position that he had DNA on him of one of the decedents, if they take the position he had GSR in his hands, but they're going to toss that case, then how in good faith can they say, we got more evidence against Mr. Demons? That is completely hypocrisy.
Well, I suspect that's exactly what we're supposed to be. But before you start, Mike, you good? That same two questions we spoke to is on the video, phone location from October 26, 2018.
Yes, it is, Your Honor.
You agree with that?
I do.
Okay. All right, so in both parts, your argument that you want me to continue to find proof evidence presumption great, and I guess that if I didn't find that, or I was going to exercise discretion, anything you want to tell me about conditions of pretrial release, or anything like disagree with regarding those conditions? Go
Yes,
ahead.
Judge, thank you. So that's a prong one, proof evident presumption rate. Not only has Your Honor previously found proof evident presumption rate, Your Honor specifically stated in your order that was issued that you were not considering any of the suppressed evidence by Judge Murphy. So there's no change in circumstances there because that was already not considered by Your Honor. Additionally, the defendant has been found to be held no bond, not only by Your Honor, by Judge Murphy multiple times, and by Judge Siegel multiple times, despite any change in circumstance of his other case, because Judge Siegel had the case before those charges were ever pending and held him no bond, as did Judge Murphy after the trial before those other charges were filed. There was a bond hearing. So regardless of the other case, he has been found to be held no bond because proof evident presumption rate has been proven by the state. Additionally, Your Honor, to discuss Ms. Boutros, which again, I objected because was never discussed in any of their evidence that they presented to Your Honor today, we can go on and on about Ms. Boutros, and we did at length in multiple hearings in front of Judge Murphy, in which the state has filed filings where you could say the same, things about Ms. Boutros that were just said about Detective Mirhadi. Opinion is an opinion, and those can be argued in court at a different hearing. But for purposes of this hearing, that was not presented to the court in transcripts of any sort, and I'm asking the court to simply rely on what was given to Your Honor at the prior hearing that we said we were relying on. And that's the evidence of this actual case. Take Detective Mirhadi out of it, you still have the evidence, some of which Your Honor has touched on. The video of the defendant himself getting into the vehicle in the exact seat that is alleged to have been the person, the shooter, shooting the two victims. In addition, we not only have his cell phone evidence of the towers, which you want to get into the FBI agent versus Detective Mirhadi it doesn't matter because it's not that they're contradicting themselves. It's that the FBI doesn't testify to certain things because they have certain parameters they're stuck to versus other officers who can testify to other aspects of cell phone towers. In addition, we actually agreed when we were about to try the case last time that Detective Mirhadi would not be testifying to that. We actually hired other experts that have been hired. And so Detective Mirhadi testifying to that does not matter. In addition to that evidence, we also have the defendant's own cell phone, which presents its own problem that I think the defense has to actually address, because in the first trial, they said, not my phone, community phone, no issues, right? We can talk about anything in the phone because it's not my phone. Attorneys then came in and said, no, we're filing a motion to suppress, and we're going to say for the purposes of the motion to suppress, it is our client's phone. And that, I believe, since we're talking about Mr. Adelstein so much in this hearing, Mr. Adelstein specifically said, we will make that determination and have to let the court know before trial whether or not we are going to say it's his phone or not. So we haven't had that determination yet. We haven't been told. So that's still an issue that has to be addressed. But in that phone, the defendant's phone, we have movement activity, health activity that has come out, step activity, all pointing to the defendant using his phone during the time of the crime, which would put him in the car, put him at the crime scene. Discussing Cortland Henry's dismissal, it shouldn't speak volumes because, as Your Honor notated, decisions like that are made all the time for strategic purposes or whatever it may be, but it does not matter. What matters is we know where the defendant was sitting in the car. Mr. Henry was the driver, and we know that Mr. Henry was not the shooter. The defendant was the shooter. To say there's no eyewitnesses, to say, sure, there's no eyewitnesses, but there were no eyewitnesses when Your Honor considered all this evidence a year ago. And there still is proof evident presumption rate. And as I said earlier, Your Honor did not consider any suppressed evidence. I can now move on to my prong 2 argument if Your Honor has any questions. As to prong 2, Your Honor, should Your Honor either find proof evident presumption great and exercise her discretion or not find proof evident presumption great, we would still ask that the defendant not be released from jail. We've spent a significant amount of time today discussing his 7 years in jail and the conditions of his, where he's staying and how he's being treated. The only reason the defendant is not in general population, in a regular dorm, in a regular pod, is because of his own actions. There is an evidence, hundreds of pages of violations, of things he's done, the chances he's been given. And what does he do? He continues to manipulate the system, continues to violate rules, not follow rules, and he's being babysat 24/7 by law enforcement. And we think that a security company that he's paying for is going to be any better? I don't think so. The defendant, as recently as January of this year, was found to be in possession of cell phone chargers, was shown on the internet to be FaceTiming some woman in violation of the rules, and that deputy was in fact arrested for giving him that phone. Hearing from his grandma about the letters that she's written that were returned, he gets letters. We see the mail, it comes through, he gets it, he sends it out. So that I don't know why her letters are not getting returned. And I already addressed the former testimony of the FBI agent versus Detective Mirhadi. And as Your Honor indicated, we have the defendant getting in the car, the cell phone location, all that evidence points to the fact that he was there. And so his inability to follow the rules and regulations while in jail, where there's some of the strictest rules and regulations. If we expect him to then follow rules of no social media, no contacting witnesses, things of that nature, while he's out, I mean, he's proven he can't. There's evidence of him, which, although we've dismissed the tampering charges, that evidence is still evidence that is admissible in this trial against him as consciousness of guilt while he's trying to get a hold of Mariah Hamilton, who is a witness in this case. There is evidence of that. And so, based on the defendant's actions through 7 years of him violating rules, of not listening to the deputies, of manipulating the system, he should not be let out. I don't believe there's any sort of conditions that could make sure that the community is safe, that the witnesses are safe, that this trial is safe from all that he has done in the last 7 years. And I'm asking that he be held no bond.
Sorry, you guys.
Thank you.
Anything else you want to say?
Yeah, just real quickly. I just, on the proof evident presumption, great. I'm not gonna start trying the case, but I have reviewed everything. I'm not quite sure where I read that the state knows, of Florida knows that Mr. Demons was a shooter, and Mr. Henry was a driver. They already said they believe that he was a liar. So I'm not quite sure where that is, which is why I went through all the different types of evidence that could have been found. Not quite sure. A phone. But other than that, I'm not quite sure where that came from. I haven't seen anything that says that he was a shooter. Not one thing. So not quite sure unless there's going to be something that came up over the last couple of years since the 2023 trial. Nothing like that you'll find in the transcript. As far as the conditions, respectfully, Your Honor, the babysat thing. I mean, like he's being done a favor that people are babysitting. He didn't follow the rules. I mean, it's Judge, it's just kind of disgraceful. It really is. And we're not talking a rural community. We're talking a major city and an important state. And this is the way he's being treated, because he should be happy that he's being babysat. He should be happy that he has a basketball court all to himself, because he wrote some note to somebody to make them feel better, because these people feel pity on him and feel terrible that he is in isolation. His mom is in the hallway crying when she hears the testimony about how her child lives. And so I think to say that it's going to be no better when at least he is released so he can feel the tenderness, the hug of his mom, so he can have that beautiful grandmother whisper in his ear, "I love you," so we can see his brother and sister and these people that love him. To compare that to his infractions for not putting his linens away, because I read every one of those infractions, and it's garbage that it's thousands. It's garbage, okay? There's a lot in there where they're worried about him psychiatrically, where he's manifesting strange behavior, pacing back and forth. That's in there, okay? And I don't know where that thing came about the nurse, because that nurse note I read about that was somebody concerned about him, okay? So to compare the two is really just shameful, Your Honor. We'd ask that a bond be set and that the court take that into consideration, suggestions that we met. And I would also add that please be mindful of the fact that Cortland Henry was on pretrial release a substantial amount of time, Your Honor. And so precedent does exist in this case. Thank you.
Okay, listen, regarding the bond hearing, I appreciate your time, effort, and energy on both sides. I'm gonna review everything, I'm gonna review all the items and evidence, and I'll get you a written order, but I appreciate the effort. Mr. Findling, you wanted to talk to me about the
I do.
set trial order?
Yes, I do. So counsel did say we've been in regular, now we're on the other side of this hearing, we've been in regular communication with one another, and we're trying to, I think everybody's trying to forge ahead. If Ms. Howe and I can make a couple of suggestions, and that is that we did look at your last pretrial order. We think it's great. We would just ask one thing, and it's crazy to hear attorneys asking for this, but we think that we should, one thing is have maybe a date or dates for motions before. We just noticed in the last pretrial there wasn't anything set, so we were hoping that you'd set some point in the future for both sides. Let's get all these motions out of the way. Particularly, we're concerned about motions in limine, not being critical of last trial, but I'm sure the state would agree with this. We haven't had this conversation. There was just so many 3-hour breaks that probably could have been resolved through motions in limine. And we're willing to live with that obligation so we can try a case that doesn't stop at 1:30 and then you got to let the jurors go at 4:15 because the lawyers are all still talking. So we would ask that be incorporated into the pretrial order we anticipate coming from Your Honor. And the last thing is, and this is, again, no fault of the state, we are struggling to understand the discovery that we have. The state has sent us what they believe we should have. We've gotten things from previous counsel. We're kind of hoping that maybe we can have like a discovery conference with the court at some point. So we know going into the trial, because we noticed in the last trial, there were these issues, and it was particularly from the defense, candidly, where they would say, we don't have this, and then they would find out they did have it. We just don't want to deal with any of that. And so we were just wondering if perhaps we could set something where we can all kind of make sure that we have everything that we have. Is how, am I stating all that correctly?
Yes.
Anything you want to add? Come on.
Just that it has become clear there are things that, and I'm not casting aspersions, but that we should have from prior counsel that we do not have. And so the state has provided some things when I figure, oh, we don't have this. But I am concerned we're gonna go in and it was provided to prior counsel and we won't have it. So I think that's really our concern.
Well, I mean, listen, as far as pretrial motions, I set all my hearings myself. It's a luxury that I have of being assigned to this division, but all you have to do is file it, and whatever you file, and then similar to these, I'll bring everybody in on status. You can appear on Zoom or in person, and I'll give you a hearing date.
That's fine.
I can control my own schedule. It's not a problem. I'm booked out with murder trials right now to the end of 2027, and it's about to be to the end of 2028. We're about to do another round of that, which I'm happy to do. I think that's not a good. But as far as the discovery conference, I'm kind of leaning toward moving back to the lawyer. I mean, if I can't get homicide prosecutors and homicide defense lawyers to talk to each other and figure out what the evidence is, I don't know if that's my job. And I can assure you, I'm not going to have a jury sitting in the back for 3 hours for anything. Because I could give you all the sites in the world. I don't prejudge anything, but when those situations have come up in the past, I determined that whatever side says that's used, whether it's the state or the defense, you've waived that at this point. This gentleman's been in jail 2,638 days. And that's judiciary's fault. That's the judiciary's fault. But I'm fixing that. This trial should have happened last September. But the appellate court told me to stop. The defense came and asked me to continue. I said no. The state asked me to continue. I said no. The appellate court told me to stop. I have to do what they say. And then they changed nothing. So this trial should have already taken place. It's done. And when we arrived at the special set trial date, starting on January 6, 2027, this trial is going to go forward. Part of the special set trial order that I've already entered is that both parties are to make available for inspection by opposing counsel all trial exhibits to be used at the trial. So if you think that's not happening and you all can't work that amongst yourselves, I guess you can use the online scheduling system and file a motion to compel. I'm going to be hearing. I don't know what else to say. The way I used to do it with Judge Coleman, who was a homicide prosecutor when I defended these cases, and Judge Holden, who was a homicide prosecutor when I defended these cases, and Judge Rivas, who was a homicide prosecutor when I defended these cases. If I needed something, I'd call them on the phone, and they'd say, "Come and get it." So I'm going to leave that to you.
Judge, can I just ask a question that, and this maybe is appropriate for the state, is the evidence with the clerk or was it returned to the state?
It's returned to me. So I
Okay.
And as Your Honor knows, we routinely do what Your Honor is saying of defense attorneys call us up, come look at everything. If the police department or with us, it's
I mean,
us.
we used to actually arrange a time and go to the police department, the storage facility, or where it was, put it all on tables and look at it. That's what we used to.
That's what I have always done.
But I have great confidence that all of you all will be able to figure that out. If you can't, I'll motion to compel, and you can set it for hearing on any day available on the electronic scheduling system. You don't even have to coordinate with the other side, and I'll give you hearing on it. But as far as evidentiary motions, or if there's going to be capital motions, or whatever the case may be, just file them. It's a courtesy copy in my office. My JO will reach out immediately, schedule a status date, and at that status date, similarly what brought us here today, I will set a date, time that's convenient for all parties, and give you as much hearing time as you need. All that can be resolved prior to that.
Judge, can I add one more thing? And that is, from my review of everything, there are some motions that were filed but not heard by the state. And so I would like to know whether they're still going forward on those motions. They've yet to be set for hearing when we're setting hearings. So that's where I'm sort of lost.
Is there something they want to hear? I guess I'll do.
And do we assume if it has not been set for hearing or it doesn't get set for hearing, we're not going forward on it?
No, I had asked you last time if I could set them, and you said you needed time to get caught up, so that's why we have not said anything.
Okay, so we're caught up and ready to set hearings.
Okay, but listen, I will make myself available.
Great.
We're gonna give you as much hearing time as you need. This gentleman's case is gonna go forward.
Thank you, Your Honor. Thank you for the time.
Anything else I can do for you this afternoon regarding Mr. Demons? Today,
No, we're good. Thank you, sir.
state, anything else I can do for you regarding Mr. Demons?
No, Your Honor.
Okay, y'all, that's the end of this hearing. It's gonna be late, but I cannot wait. I have to see Kenny Capps' testimony, so I'll put the link up. Y'all know I'll try to make it, but it'll probably be my lunch break. But I just can't wait. I have to watch his testimony. So y'all enjoy the rest of your day. Thank you guys so much for being here during the stream. Thank you for the super chats, all your kind words, the comments, and liking the live. I appreciate that. Thank y'all for all of the memberships that were given today. And I'm gonna see y'all later. But those of you will be up. It won't be until 10. I'm telling you right now. And I'll be on for like 2 hours. That's it. So if you're going to be up like me, because I don't get off until 9. If you're going to be up like, no, I get off at 10 tonight. Come on over. I'll be here because I have to watch Robert Howard. I need to see what it is Gonzalez is trying to do with him. But see y'all later. Thank y'all. Bye-bye.